NAMI Urban Los Angeles. We're going to be presenting a program here on how to obtain a LPS conservatorship for your loved one. We want to let you know that this meeting will be recorded, and because it is recorded, later when we have question and answers, be sure you don't mention your family members or loved one's name because of HIPAA laws. So you can just say, you know, my son, my daughter, or someone special to me. That being said, I guess we will start the first slide here. So in regards to today's meeting, again, it's NAMI Urban Los Angeles that is presenting this for everybody. And although this is a NAMI Los Angeles presentation, know that the LPS laws are applicable in every California county. So all the laws and so forth will definitely be applying to whatever county that you're coming from, because we know that we have people here from multiple counties actually, but predominantly LA. So that being said, Gail Evangelotti is with me today. She's on board here with NAMI Urban. She's the NAMI Urban LA Conservator Mentor Specialist. She's taught me almost everything that I've ever learned, and I've enjoyed working with her for a number of years now. And I'm Jim Farrell. I have a Orange County Conservator Assistance Group. Our information is going to be coming up soon, so if you want to get your pencil and paper out, you'll be getting our phone numbers, and you can call us with questions after the meeting. Also with us is James Kwan. He's the Deputy Director of the Office of Public Guardian for Los Angeles, and he'll be sharing information that'll be very valuable to everybody. And from the Department of Mental Health also is Linda Boyd. Linda's the supervisor of the Care Court program for Los Angeles. And also we have Venus Nagai. Forgive me, Venus, if I'm mispronouncing that. But she is the DMH supervisor for Assisted Outpatient Treatment Program. And some of you may not be familiar with the AOT, or the Assisted Outpatient Treatment Program. I was helping someone here in Los Angeles, or excuse me, Orange County, with the same type of help that they offer here with AOT. So that is actually statewide. So we have a good program for you. Thank you for coming, and we'll go on to the next slide. So again, these are the contacts that I told you that would be coming up. If you want to write down Gail's information, please note that Gail is actually residing in Florida, even though she's from LA. And if you call her, keep in mind that she's 3 hours ahead. So you think, oh, well, it's 8 o'clock. No, it's 11 o'clock there. So be careful of that.
Thank you, Jim.
I thought you would appreciate that.
So,
again, if you need to reach out to Mr. Kwan, you know, with the Public Guardian's Office, he's very amenable to taking phone calls from all of you. That's his number that you can call him on. And Linda is just an amazing phenomenon as well. Yeah, and then Venus, this is her number. So there's our numbers. You write down the ones that you think you need to call later. And if you didn't get all of them down, we'll help you out with that later. Next slide.
take a picture of a slide. If there's a slide you need to know, use your phone and take a quick picture. That'll help you.
You know, I don't know how to do a screen capture for DOS or, you know, those type of operating systems. But for those of you that have a Macintosh and are watching this, if you hold down the Command Shift 4 keys all at once, it'll open up a little plus sign or like a cross. You can just click that on the screen and drag it across, and it'll form a box. And when you let go, everything inside that box will be saved to the desktop. You can review that later. That'll save you a lot of writing. So we're going to be building a case for mental health treatment. We are going to be acquiring financial resources and insurance information will also be shared, how to acquire that. We'll be discussing the LPS treatment possibilities and other treatment possibilities besides just conservatorship. And then, you know, what's involved in seeking hospitalization treatment, seeking outpatient treatment. And of course, we're going to be talking about medications and the mental health laws. Next slide. Gail?
Oh, okay. This is just a disclaimer. What we do in this program, Jim and I share with you the information that we've learned from you, actually, that's going to give you the greatest probability of a successful recovery for your loved one. So, a lot of times when I say call back and let me know what's happening and how things are happening, I've gotten a lot of good information from you all. I mean, I've walked a lot of paths, but I haven't walked everyone. But you guys have, and you give us the information, and this is the compilation of everything that we share with you. Um, we give you the information. We are not telling you what to do. We're making suggestions. You are in the moment. So if you say, well, this is what they said to do, and you go, I don't think that's a good idea. Do what you feel is right. You are in the moment, you know your loved one the best, and make that decision. Right or wrong, don't worry about that. You can go back to the drawing board and you can do it over if you have to. Um, so that's the situation. Um, just let me see what else is on this. Yeah, make the best decision you can for your loved one and just let it go at that. Next. Next slide. Thank you. We're going to do a written case for treatment. This is not an application for LPS, AOT, care court, or anything else. What this is, it puts together information in a very concise way that you can use it for everything. And believe me, the judge, the attorneys, criminal court attorneys, AOT, care court, they all appreciate it because it helps them to do a better job of deciding what to do with your loved one. For the doctor, they can give them a better diagnosis. So we're going to write a written, powerful case for treatment, and it's just going to help other people to understand it better. Next. Um, Use that written case for acquiring Social Security income, SSDI, Social Security disability income, Medi-Cal, Medicare, and getting the police. When the police come out there, if you give them a copy of it, they have a better idea of what is going on. If they ask your loved one's going to tell them they're fine, but you're sick and they need to take you to the hospital. I'm sure you've probably had that happen, but this will help them a lot. When you're requesting care court, AOT, full service partnership, LPS, this helps everyone. No one has time to listen to you tell the whole story of their birth to the present. They just don't have the time. When they're incarcerated, this is very helpful too. Um, the public defender at criminal court, it's helpful for mental health court. If they go to mental health court for competency, it's helpful. And to the public guardian's office. Do not send it to the public guardian's office until the doctor has requested an evaluation for LPS, then do it. But until the doctor's done that, the public guardian doesn't come into play on helping your loved one. All right, next one. The acquiring resources. This is very important because these resources open the doors for treatment. SSI is Social Security Supplemental Income, SSDI, Social Security Disability Income. People get Social Security and veterans benefits. The insurances, those were income, money that comes to you. Insurances, not to you, but for your loved one. Medi-Cal, Medicare, and private insurance. So you want to acquire resources. Next slide. Jim?
Yes. So for SSI, SSDI, Medi-Cal, and Medicare, you want to actually apply immediately to establish a date for payments. And what I mean by that is that when you apply for Social Security, it may take, several, months, 2 months maybe, or whatever that period might be before it's approved and you actually get it. But when you do get it, they're going to pay you from the date you first applied. So you'll get this large check up front to pay for a lot of the expenses, maybe the hospital or whatever else that you've accrued. So just know that. You want to apply immediately to establish a date for payments. You want to ask the Social Security to help you fill out forms. You get forms from your doctor and so forth indicating that your loved one needs to be on an LPS conservatorship and should be on Social Security. You want to ask them to help you fill it out. Medi-Cal is usually granted when SSI is granted, and Medicare is usually granted 2 years after receiving Social Security disability.
Okay.
Anything you want to cover on that, Gail?
Yeah, I'd like to add a few things. If
Yeah.
you call Social Security and you're trying to get SSI and SSDI, and you say, I am applying for, the moment you say that, they're going to say, well, you can't apply. Goodbye. You don't want that to happen. That's why you use the words, do not use the word you are applying. Say, I would like for you to help me fill out the forms. My loved one is either in the hospital or they're going to be in the hospital. You have about 3 months to get this done. The clock starts ticking for their payment the moment they sign those papers. And most people say, I'm not signing that because I'm not sick. But when they're in the hospital, the doctor or the social workers there are pretty good about convincing them to sign that. So you give it to the social worker, give them a copy, don't give them your original, and ask them to get them to sign it. That's going to really help. Then you can give that back to Social Security. With SSI, Medi-Cal usually comes with it, but you can apply for Medi-Cal prior to. Again, I'm saying you can apply. No, you can't. You can get them to help you fill out the forms. They have to sign for it. Now, on Medicare, generally it's 2 weeks after SSDI. SSDI and Medicare go together. SSI and Medi-Cal go together. But usually 2 years after they've been receiving SSDI, then Medicare will automatically apply. And you just call Social Security and they just bingo, it's right there. So they will be Medi-Cal, and Medicare. But if you have evidence that they have been ill longer than 2 years going back, and you have evidence of that, give that to Social Security. Many times they will approve the Medicare up front. So not always, but many times they will, so you can get on Medicare right away. All right, next slide.
You want it to write a powerful, concise case for treatment. When your loved one's in the hospital and the doctor's trying to determine, what sort of an illness is, am I looking at schizophrenia? Am I looking at bipolar? What is this person's probable cause of illness? Which segment of that is that going to fit into? And so the laws, and I think it was Carla Jacobs that wrote it, and it was 1424 and later written into the Welfare Institution Code, is that you as the parent have a right to share the information about your loved one, so that the doctor that's going to look at this document that you're presenting to him will look at that. And the way it's going to be filled out, you'll see in a moment, it will present actually a very powerful, concise case for treatment when the doctor sees it, depending on your loved one's needs. Okay, next slide. So this is how you would start a mental health history format, is that you'd want to, up at the top, put the mental health history, Joe Doe's mental health medical history, and then you would put on the left the dates of hospitalization. May 1st, the hospital, Los Angeles. What was the diagnosis? In this case, schizophrenia. Again, sequential hospitalizations, the dates are very important, and what kind of behaviors were determined to be showing, with that individual in that sort of hospitalization environment. Down at the bottom, you want to make sure that you put in any medications that they may be allergic to or anything like that, and what medications that they're on. You want to also include whether or not they have Blue Cross insurance, SSI, or Medi-Cal insurance, or that you have applied for Medicare and you're waiting for that. This type of information is going to be extremely helpful for the hospital to know. Next slide.
Rick, can I just say something? When you're doing the mental health record on that, only put the person's first and last name, no middle initial, no social security, birth date. Do not put any of that on there because this is going to go through a lot of hands. So you just want this. And you only put 4 things. The event is hospitalization, homelessness, incarceration. And there is always a diagnosis. If you look at homeless, you've got exhibiting psychotic behavior. They're not out there doing research, writing a book. It's exhibiting psychotic behavior. So if you don't know a diagnosis, exhibiting psychotic behavior, always have a diagnosis on that. Okay.
Next slide. Oh, here we are. I'm sorry. Down at the bottom of the history page, you want to list any allergies, medications they should not have. For an example, my conservatee cannot have Haldol. It causes his tongue to swell and shuts off his airways. So that's very important in my case that I want to put that in there and make sure that it's legible and easily to spot. You want to put down any medical problems like, diabetes, heart problems, and what sort of resources are available such as SSI and Medi-Cal. Next slide.
You can also put at this point that you applied for SSDI, Medi-Cal, whatever else. And if they have private insurance, put that down.
Okay, thank you, Gail. Next slide.
Okay, oh, that's mine. The symptoms and characteristics, the doctors have heard it all before. So you only put phrases, and it starts out with visual hallucinations, all this copy and paste, and use this identical format because we've got good results with it. Not perfect, but good. If they don't have visual hallucinations, delete the whole section. If they do, and you know what they're seeing, you can bullet. You can put 2, 3, 4. You don't have to limit it to 2. Auditory hallucinations, delusions, beliefs in the delusions. Now, if you are using a specific one from this, like FBI's telling him or her to do something, and you have a son, then delete the her. If you leave it on there and the doctor is reading this, and believe me, they can read this in about a few minutes, and they see the her, they go, copy this from someplace, discard the entire thing. So proofread your paper. Do not say anything positive about the person, not at this time. Once they're in treatment, then I want you to look at the photo album, and that's your goal, to get them back to that person who they were before they were ill. And that's basically through medication. Okay, the delusions, there's lots of examples to help you to think about what to do. Remember, say nothing positive and make sure everything sounds like mental illness. For instance, and I've mentioned this before, they keep their room messy. You've qualified every teenager in America, but if their room is uninhabitable, that's a different story. All right, next slide. Here, Sally? Hello? Okay. They behave in accordance with their paranoia thinking. There's examples in there, and many of them you've heard before. Unable to meet the needs of daily functioning, and that's a very important one. Wearing their clothes for long periods of time, taking their clothes off at inappropriate times. When you read this, you're going to say, my loved one does that. My loved one does that. Next slide. Okay, these are important things at this time. And now keep in mind, the laws have changed, but they're not being enacted until January 1st, 2026. So we are teaching you things on the old law, but we will also mention what's going to be happening with the new law as of January. If you say they're violent, they beat the crap out of somebody, it's very hard to find a treatment facility that can take them other than a state hospital. What is it? Patton or Metropolitan. So what you do is you say they're highly aggressive towards mom, towards dad, whatever. Do not say they can come home. The hospital will tell you, you're asking for the LPS conservatorship. And the hospital says, but they don't meet the criteria. So we're going to release them today at 3 o'clock. Will you be picking them up? Hospitals aren't always in the best of town. And so it's your daughter. Yes, I will. They were correct. They did not meet the criteria because the law says they have to have a serious mental illness and be considered gravely disabled. Gravely disabled is defined presently that they cannot provide for their food, clothing, or shelter. But if someone else is willing to provide it, then they are not considered gravely disabled. So the moment you say, yes, I'll pick them up, the hospital's correct. Now, with that said, I am not saying to put them on the street because that makes life a lot more difficult in getting them treatment. But if it were my child, I'd tell the hospital no, but I'd sure as all heck be sitting in that parking lot waiting to collect them. So, I mean, it's kind of a difficult situation. Florida says if someone has to provide their food, clothing, and shelter because of their mental illness, they are gravely disabled, which makes a lot more sense to me. Okay, next slide.
So various examples of psychosis might be that they have heightened sexual delusions. They may be racially against everyone who is not them. I'll let Gail share that one with you because it's just amazing. FBI, CIA, and others, they're following them. I remember my conservator when they were much younger, coming home from school, said somebody was following him from school. These are real clear signs of psychosis. You stole their $2 million. Well, you know they don't have $2 million. And that we have the problem. They don't have a problem, we have the problem. So these are kind of insights into psychosis. They start kind of talking off the grid and just kind of, this is to give you a heads up on that. Next page, please.
Well, let me just make a comment about the first two. The racial against everyone who's not them. We had a fellow who hated Black people. I mean, just hated them. And his mom goes, I don't get it. He's Black. It doesn't matter. They tend not to like anybody who is not them. Doesn't matter their religion, the color of their skin, or anybody. If they're not them, they don't like them. And that's a very common thing. If you've seen that in your loved one, it's not 24 hours, comes and goes. The heightened sexual delusions. Generally speaking, you can tell whether it's real or not, or at least you have an idea to investigate it. If they tell you, I was molested by somebody, oh my goodness, when did that happen? It happened. You know it happened, would be their answer sometimes. Well, what were you wearing? Where were you? Sometimes they can't give you specifics, but if they give you specifics, I sure as heck would be investigating that. So, I mean, you have to listen to what they say. Sometimes their reality is telling the truth. I'm just going to give you an example of something to help you understand where they are with their thinking. When you have a dream at night or a nightmare, 1 minute you're here, 1 minute you're there, nothing makes sense. You don't have any conscious of, oh, I shouldn't be doing this. You just go through the motions. And when you wake up, you may or may not remember much. That is where they are. So that hopefully it will help you to understand where they are. So don't try to explain and say, no, you're wrong and this and that. That is their reality. And you kind of have to respect that a little bit. Okay, next slide.
So you want to acquire resources for treatment. You'll contact the Social Security office, provide them with your written case, ask them to, again, as we had talked about a little bit prior, ask them to assist or help you fill out the forms for your loved one. Don't say you are applying for resources. Gail went over this pretty thoroughly prior to this slide, so we don't have to really get too much into it. Just remember that it's your loved one who must sign for all these resources and must actually be the individual applying. And that sometimes can be challenging. Years ago, I remember at one of Gail's meetings in a hospital setting, there was a family who had spent their entire retirement funds that they had accrued over many years, and they had spent all of this on programs that were supposed to help their loved one, and it didn't help them, and the money was gone. So a lot of times people say, "Oh, we don't need Social Security. We have lots of money." Well, it'll all go. So just keep in mind, it's a very expensive proposition to treat mental illness, and you do need to consider it very strongly. Next slide, please. So government resources that are available, SSI is Social Security income, SSDI is Social Security disability income, Social Security is a source of funds, Medi-Cal insurance pays for a whole lot, Medicare benefits, it pays for your hospitalizations and so forth, and veterans benefits. So there's quite a few resources for families to tap into to fund this enormous cost of treating your loved one's mental health needs. Next slide. For your insurance, you can have Medi-Cal, Medicare, and private insurance. What you want to understand is that if you also have the private insurance and you submit a bill to Medi-Cal, they're going to want to see that your private insurance will pay as much of that as they are required to pay, and anything that they won't pay, then Medi-Cal will cover the balance, as will Medicare. Private insurance may pay for the facilities, but if not, you must have something in writing from the private insurance company that they will not pay for the treatment. Then Medi-Cal will cover the expenses. Okay, so those are all necessary kind of items to have and understand how they work. Next slide. So Cal-Able income, you can.
Tim, may I just interrupt for a second? Just when you're applying for SSI or SSDI, when your loved one is in the hospital or they have a treating doctor, before you're getting that income, and you do not need LPS conservatorship to get these resources, ask the doctor to fill out the form for you to be representative payee. If you're representative payee, then you have control of the money and they can't go using it for things that they shouldn't be using it for. So, and you would show that to Social Security, open up a bank account, both your name and their name. It's deposited, the money from Social Security would be deposited directly into that bank account. You have control of it, but it's reported as their income. Okay, go ahead, Jim.
No, thank you. So Cal-Able allows you to supplement your loved one's income. I had a situation where one of the board and cares that was going to take in our son was charging a higher rate of billing than what his SSI was going to cover. And so consequently, I discovered that I can open up an account for my son in that case. I could then supplement my funds into it. And then from there, I could, through that account, pay the additional funds to the board and care and not be penalized. Any time that you have SSI or SSDI and you're taking money out of your pocket to pay for your sons or daughters or loved ones' expenses, if Social Security becomes aware of that, they're going to dock you for that amount of money that you've provided. However, Cal-Able is a great go-around to bypass that problem. So you might want to look it up, and I think we have a couple slides here that are going to talk about a few other items on Cal-Able. So next slide.
Wait, Tim, you want to go back? You missed that 2,000 and 3,000.
Which one? Oh, yeah, I sure did. I'm sorry. Thank you, Gail. I sure missed that one. Do not allow more than $2,000 in the account at any time. And if married, do not allow more than $3,000 in the account at any time. I will share with you that Social Security, I probably shouldn't be telling this, but I will. Social Security here in Orange County informed me that they don't really know what's in the account until towards the end of the month, and it's towards the end of the month that sends the account information over to them, and all they're providing them is the current balance that's in the account. And because I have a situation now for my conservatee that in a treatment facility, we had to shut off his SSI, but he still gets his SSA. It's mandated. So here comes $500 a month, and what am I going to do with that? They told me we'll put it into the CalAble account for him. And then later, another person from Social Security said, "No, don't do that. Just keep drawing that money out and hold it to the side so that it's not in the account." I don't know. I'm not here to tell you what to do, but it's just interesting how the system works. I don't know if SSI only reports in the amount that's in your account in every county the same. I would think so, but you want to do everything you can to prevent that amount of money that your loved one has in their account. You want to prevent it from going over 2,000. They will shut down your income, your SSI income and SSA and so forth, as long as you are over that $2,000 mark. So watch that very carefully. Next slide.
Yeah, the other thing is they will also audit you. So near the end of the month, when you know money's going to be put in there, and you go, "Oh my goodness, that'll go over," be sure to get that money out quickly before.
ASAP.
If it goes like and this is only for SSI, SSDI, this does not apply.
Right.
But if it goes to $2,001 and that's what it shows to Social Security, chances are they will audit you. It's not a big deal, but it's extra stress that honestly you don't need. So we're trying to help you avoid some stress that's not necessary.
Okay.
Okay, that's a representative payee. Be sure to get the treating doctor. It's not a big deal. It's one little form the doctor fills out. You can ask the the social worker to have the doctor fill out the form so you can be representative payee. You give that to Social Security. They approve you for being representative payee. And then you give it to the bank and you open up a bank account in both names. Remember, it's reported as their income, but only you have access to that account. Now, because many of our kids are brilliant, do not let them know what bank account it's in or anything at all about that account. The teller, if they know that their SSI money's coming to Bank of America, they'll go there and say, "I have an account here and I need to know how much money is in there. I need to draw it out." The tellers do not understand representative payee. That's why I say, keep that on the quiet, because honestly, if your loved ones find out, they're clever and they're running 10 steps ahead of you. Next slide. Treatment programs. These are some of the basic ones that we have in Los Angeles. These laws are across the county, across all of Los Angeles, but not all counties are instituting this, and they all take the law and they enact it the way that they kind of feel is for what their needs are. LPS conservatorship is your involuntary mental health treatment. It is the only one that can actually mandate medication. And you need the medication to supply the chemicals in the brain so those neurons can connect properly. So it's the strongest treatment program there is. There's other things that go along with it, but when you come right down to it, it mandates medication. Assisted outpatient treatment is a pretty darn good program, especially if that person has reasoning ability. The people that work in there, Venice, Nigel is the supervisor, Linda Boyd was for a while, but they do a great job on training these people how to work with your loved one, how to talk with them. They come right to your house and they will provide everything you need. You need a psychiatrist, a social worker. If you need a place to live, they will help you get a place to live. Now, it won't happen within 24 hours, but they will help you. They do a pretty darn good job. A care court is and Linda Boyd's going to be talking about this. It's schizophrenia spectrum. They pretty much the same as AOT, but highly trained people, very good. And again, they come to your house and they work with your loved one, and they know what they're doing. Not that your loved one is going to pay attention, but if they have any reasoning ability, chances are they're going to break through and get them to be compliant. Full service partnership does the same thing, and there's criteria to get into each one. Okay, next slide. LPS laws. The involuntary mental health treatment is referred to as LPS conservatorship. That's specific for California. Other states call it different things. You do not want a guardianship in California. A guardianship means you are liable for anything they do, don't do, and financially. So you don't want that. As an LPS, if you choose to be the conservator, and we talk about that too, you are not held liable for anything they do, don't do, or finances. But to get the LPS conservatorship, you have to meet two things. One, the person has to have a serious mental illness diagnosis and be considered gravely disabled. Now, if you get insomnia at night, a good thing to read is the California Welfare and Institutions Code 5200, guaranteed to put you to sleep. Next slide.
So the types of serious illnesses, mental health illnesses, are listed as schizophrenia, schizoaffective disorder, bipolar, chronic depression, co-occurring substance abuse disorder, and it can be, that the individual is struggling with substance abuse, mental health, when they take the, the abusive drugs out there that are on the market, then that just kicks a stool out from their mental stability. And then you set up this whole cycle of in and out of hospitals, in and out. And we want to do the best we can then to connect them for treatment services for both. Next slide.
Wait, let me just make a comment about that, if we can go back to that. This is the new law as of January 1st. Right now, don't mention, excuse me, anything about substance abuse, because the hospital will say this is a substance abuse disorder and they will discharge your loved one. So until January 1st, don't go there. Now, if you're dealing with care court or AOT or full service partnership, you can. But if you're looking at LPS and the loved ones in the hospital, don't mention to the hospital at this time about substance abuse. As of January, this is the new criteria. The last two, co-occurring substance, is going to be considered part of it. And if you cannot provide for your personal safety or your necessary medical care, that too is going to be the new definition of gravely disabled. Now, that sounds all fun, all wonderful. Wow, look what we're doing. I will tell you, if you can't get LPS on just the basics, schizophrenia, schizoid affective, bipolar, and chronic depression, you think adding those extra two, you're going to get LPS? No, it isn't going to happen. So they make these wonderful laws, and I'm being very cynical, I apologize for that, but try to get the doctor to do the LPS. They're not. And right now we have one hospital after another that's saying, we don't do LPS conservatorships. Yet DMH has approved them for doing LPS conservatorships. So I'm cynical and I'm angry. Okay, next slide.
Okay, LPS conservatorship and voluntary mental health treatment. For the definition of gravely disabled, it's stated that a condition in which a person, as a result of their mental disorder, a severe substance use disorder, or a co-occurring mental health disorder along with severe substance disorder, is unable to provide for their basic personal needs for food, clothing, shelter, personal safety, or necessary medical care. So basically, you're looking at um, the new laws that are coming up, and like, as Gail was saying, that at that time that the new law goes into the effect and the counties are able to implement it, it would be, I think, safe to say that yes, my loved one's co-occurring currently until they get things set up in direction, especially in Orange County. I think they're almost a month out yet before they can start that program. I would not mention that to the doctor that they have a substance abuse.
Not at this time.
Yeah, just keep keep it under wraps.
Yeah, I'd also like to add something. If you're going for LPS conservatorship, it has to be that the doctor has to initiate it in the county of record for your loved one, where your loved one is living, or actually where they get Social Security, Medicare, any of that. It has to be in that county.
Right.
If my loved one's resident is Los Angeles and he might be hospitalized in Orange County, if the doctor applies to Orange County for the LPS conservatorship, it won't be granted. It has to be in Los Angeles. And they're doing everything by WebEx now pretty much. So they can apply to that particular county. Orange County can apply to LA County for the conservatorship, and that would work.
Right.
Okay.
So under the terms gravely disabled, I'll just read it. Shelter may not come and live at home. Your loved one has no place to live safely. They can't handle a shelter or a board and care safely. Food. They've lost significant weight from not eating. A lot of times individuals think that their food's poisoned and they just don't want to eat food. They're paranoid of the food being poisoned, or they're overweight because of compulsive eating. These are all, I would say, areas in which you could say the person's gravely disabled. The person may take their clothes off at inappropriate times and places. And I've seen that, and it's so sad. And unfortunately, that's at a much younger period of time in my life. When had I have known, I would have called, behavioral health on that instead of just the police. But they may also wear their clothes for excessive periods of time, never take off their clothes, sleep in their clothes, do everything in their clothes. And there's just, this crust is on the outside, That's really so dangerous for their health, And so quite often this individual then with their mental health, they lack insight into the illness, and therefore they will not take medication, and they have a history of non-compliance. I've had families call me, and after a few phone calls became aware that the individual had an insulin pump, and he became really positive about the fact that, hey, this insulin pump is poisoning me, it's going to kill me. And he shut the thing off. I don't know how, but he did. And so when the treatment team came out, the CAT team came out, they weren't so sure they're going to transport. And so I said, oh, by the way, and once they became aware of the fact that this was a gravely disabled individual, they did transport. So these are areas in which they could become eligible to receive a label of being gravely disabled. Gail, anything you want to throw in there?
I would apply the food, clothing, and shelter right now. That is all they're looking at. After January 1st, it's more, and it would be like that insulin pump. But everything, I would refer to everything as a health risk or a safety problem. If you just say, well, they don't have any place to live, they're going to send them off to a shelter. But you let them know that's a safety problem. And I'm going to add, actually, I am a story that we heard. One fella goes to LPS court, tells the judge, hey, I'm not gravely disabled. I can get a tent from the city. I can live on such and such street. I'm fine. I can eat 5 times a day at the food banks if I want to, and I can get all the clothes I want from Salvation Army. The judge had no alternative, but he had to release him. He did not meet the gravely disabled standards. Now, if a family member had been there, and I applaud every one of y'all because your loved one doesn't even have a prayer if it isn't for a family member advocating for them. If a family member or somebody who knew him was there and said, yes, Your Honor, he can go live on the street at such and such time. But he is either being abused or he's abusing people, victimizing them. And he can eat 5 times a day at the food bank, but he's lost significant weight, causing a health problem because he doesn't. And the clothes, he wears his clothes for excessive periods of time. Don't say a week, 2 weeks, because they will use anything you say against you. So be careful what you say. Or he takes his clothes off at inappropriate times and places, or dresses inappropriate for the weather. Now the judge would have said, okay, LPS. So your advocacy is vital. The no insight into the illness, we put that in there because their history is supposed to be part of this. And many of them don't have any insight. As you know, I mean, my son took me to the hospital to have me admitted, and they were thinking about it. And I said, fine, just he will not be my roommate. Next slide.
So you really want to look at the direction for treatment. You have a recovery model, which is a full service partnership, care court or assisted outpatient treatment, AOT, which is known as Laura's Law, and LPS conservatorship, which of course is involuntary treatment. If you look at LPS conservatorship down there, number 4, they may not qualify. So then you could shift over to AOT. And I just did that recently for a family here in Orange County, where the doctor and the hospital just refused to file a LPS conservatorship on the client there. And so I connected that family then to AOT, and they're going to put together treatment. And Linda's going to, not Linda, but another person here, is going to talk about this later in this presentation. So it's very important that you learn about these different recovery models and what they have to offer for your loved ones, and then you can better determine, what services you need to set up for them. Next slide.
Hospitalizing a person. When you have to hospitalize somebody, the problem we have right now is the police are refusing to put their hands on a patient. If you figure one person is hospitalized 10 times, that's 10 trips the doctor has, or the police go out there. If they do get them to the ER, it's 10 ER rooms. We'll multiply that times 100 people. The police get tired of going out on these mental health cases. And so they've gotten to the point where, hey, we're not putting our hands on the person. If they don't get on the gurney and go, we're not doing it, because the system is not following through with the treatment like they should. If the person is harm to self and harm to others, please do not wait until they hurt somebody. When they're getting agitated or irritable, quietly go outside, make that phone call, get them in the hospital and push for the hospital. If, God forbid, the police take them to jail, it is not the end of the world. There are programs. So by the time they finish their program, that case can be totally dismissed, hopefully, or knocked down to where it's a minor thing. We do not want these people hurting anybody. So don't wait that long. If they're a flight risk, you want to call the police, ask the police to bring an evaluation team, somebody to evaluate them, to put them on a 5150. The 5150 is, in California, it's either a 3-day hold, 72-hour hold, which is 3-day hold. That's basically what you want. If they are gravely disabled, they're in their room, they won't come out, they've lost weight, you can call the access team. If they are a flight risk, ask them to bring the police. The other thing that I'd like you to do is on that paper that you do, the history, symptoms, and gravely disabled, copy that gravely disabled verbatim. Just take off what does not apply. Write 3 open-ended questions based on your loved ones, how they demonstrate their mind. NAMI tells you want to disperse the situation, bring it down so it's nothing. No, you don't. Not when you want to get them in treatment. Because what's going to happen? Next day, they may, or even that night, they might be back into a psychotic state. So you have three open-ended questions that could possibly set them out off, not a yes and no question. In other words, like, I understand the FBI's following you. How can we help you with this situation? That will get the person to talk. I understand your parents took your $2 million yesterday. How can we help you with this situation? That sort of thing, and have three. So if one doesn't work, maybe another one will, or another one will, or a third one will. But give those questions, put that on that LPS, on your history symptoms and gravely disabled, because the doctor can ask them those questions. That's going to tell them where their mind is, which is really important to know. Jim, you want to add anything?
I think you've covered it all. You did a good job. Thank you.
Next slide. The hospital's treatment time, your 5150 is your 3-day hold. A 5250 is also known as the 14-day hold. Now, within the first 4 days, and they used to say first 4 working days, but they count the weekend as working days now, they have what they call a probable cause hearing, or it could be a certification hearing. Different hospitals call it something different. That's when they have a judge go right to the hospital and they determine whether the hospital can hold the person for the full 14 days if the hospital chooses. Generally, a hospital will dismiss them about day 11 or 12 because they're not going to hold them for the full 14 days. But basically, it gives them the right if they want to hold them for that time. After that probable cause or certification hearing, if the doctor is going to initiate the LPS conservatorship, that's when they should do it, because that's going, and they initiate it with the public guardian's office. The public guardian will put the person on a temporary, a TCON, a temporary conservatorship, in which it will give them time to evaluate your loved one and petition the court for a court hearing. And if you choose to be the conservator, this is when you can talk to the public guardian's office and let them know you're interested in being the conservator. They're looking for a responsible person. Now, if they're talking to you and they say, they ask you, okay, what are your plans? And you say, I'm going to be talking with the doctor to figure out what we're going to do, how we're going to treat them. That's good. If you say, well, I'm going to bring them home, well, that's not going to quite cut it. Or I'm going to put them on holistic medication. No, that won't cut it either. You have to go along with what the doctor's suggestions are, because you're trying to get them on the road to recovery. But now, if the doctor does not initiate the LPS conservatorship right after that probable cause hearing, but he says, I'm going to put him on a 30-day hold. Within the first 5 days of that 30-day hold, the public guardian wants the doctor to, again, initiate the LPS if they're going to do it, because it gives them time to do their work. If they wait till the end of it, they're not going to do it. They don't have the time. All right, next slide. The treating doctor in the hospital or jail presently is the only person that can initiate the LPS conservatorship. This is not the law, but it is the practice. And the reason why, if the public guardian's doing all this work to evaluate them, and they suggest to the court that this person needs the LPS conservatorship, if your loved one does not appear in court, the case is dismissed. All that time and effort down the drain. So that's why they want them in the jail or in the hospital, because those are lockdown treatment facilities, and they can transport them over to the court or do a WebEx for the court. And then the judge can determine whether they're going to grant the LPS or not. But generally speaking, they should be in the hospital or the jail. Now, there's another program that's for people who are homeless on the street. And they do outpatient LPS conservatorships. And they're having pretty good luck with that also. So if your loved one is homeless and you know where they are, that's another program you can apply for. Next slide. When you go to the hospital, when your loved one goes to the hospital, give them that written case for treatment. That helps the doctor to have a better idea of what's going on because they don't know what's happened in the past. That's really good. Also, when you're applying for SSI and all that, give that to Social Security. Use that paper for everything. If they're in jail, give it to the public defender. Use that paper for everything. You can request that the doctor initiate the LPS conservatorship after that probable cause or conservatorship, not conservatorship, a certification hearing. Next slide. Okay, should you be incarcerated in Twin Towers? This is all new information that I got from one of y'all, which I really appreciate. This number, and I'd write it down, it should you have an incarceration, the Medical Command Center, they've changed the system at Twin Towers a lot. You call that number, the extension 5544, and you can request an email where you can send them the history, symptoms, and gravely disabled. The treating doctor at the jail is treating hundreds of people. He doesn't know your loved one from Tom, Dick, or Harry. So this gives them something to work with when they're doing the evaluation of your loved one. And you can request that the doctor initiate the LPS conservatorship. That's probably the easiest way to get the conservatorship through. There's also a correctional health service that you can contact. By the way, have a cover letter when you send your history, symptoms, and gravely disabled. At that point, put your loved one's name, their booking number, and their birth date, and give it to the jail because that's how they will know where they are. And there's a inmate mental health contact number, which you can fax over the information. You can tell them this is the medication they should be on, and they will try to get them on it. They cannot make them take it, but they can do their best to get them to take it. Also, if they're in jail and they go to the criminal court, the public defender who handles that, wants to see that history, symptoms, and gravely disabled. That helps a lot. Okay, next slide. All right. Via the jail, requesting the doctor at the jail to initiate the LPS conservatorships. Many times they will give them that history, symptoms, and gravely disabled. Request the public defender ask the mental health liaison, and that's in the resource number of that LPS info booklet that I think several NAMIs have it on their webpage, and I have to update it too. For the mental health liaison to be involved in the case. The mental health liaison opens doors for treatment. So give your case to the public defender and ask the public defender to request what they call a jail diversion program. They have lots of names for these. And they will try to put them in an appropriate one. Now, your loved one has to approve of that, but they're pretty good about getting them in it. If you have an LPS conservatorship when they're in the jail diversion program, consider the LPS as your insurance policy, that they will make it through that program. Because without it, you cannot mandate the medication. So if they're under the conservatorship and they go off their medication for about a week, if you are the conservator, you have the power to put them back in the hospital, which is the only place that can force the medication. And that's a powerful thing to do. And you want to do that. You do not have to wait for them to become harm to self, harm to others, or gravely disabled. The court has said they are gravely disabled. And if anybody disagrees with you, they better go to court and change it. Otherwise, they are in contempt of court. All right, next slide. Possible court cases. You have three possible court cases. You have one is the criminal court. All they're looking at to find out did or did not the person do the crime. That's all criminal court is asking for. But in criminal court, you can ask the judge or ask the public defender to ask the judge to have a competency hearing. Now you've got incompetency hearing, which is usually done in Hollywood. Is the person able to understand the case and work with their attorney in their defense? That is all they are looking for. And if they're not competent, then they will work with them and they will try to give them the medication. Then you have a third court case, because people get these all confused. These are specifically what they are looking for. The LPS conservatorship hearing. Is the person gravely disabled and do they have a serious mental illness? That is all they are looking for. So if you're in criminal court, don't think, oh, I can get an LPS here. You cannot. You have to be in the right courtroom to have the right information. And these are the specific things those courtrooms are looking for. They're not looking to mix them up, but they do complement each other. Okay, next slide. Welfare and Institution Code 5008.2. Like I said, you can read the 5200 and fall asleep, but it still has a lot of good information. The law requires that all healthcare providers shall take your information. So when you go to the hospital, and we've only had it once or twice, but we still get it every now and then, somebody will say, I can't take your information. This is the law, that they have to take your information, and the historical course of that person must be taken into account for treatment. So that's important for giving it to the police. They have to take your information. The court, the hospital, they all have to take it. The court stated in a court case that through neglect or inability to care for oneself, if the person lacks the provisional sense to care for themselves due to their mental illness, then they meet the criteria for the 5150. Remember, it's harm to self, harm to others, or harm to others, or harm to others, yeah. Let's say the person's standing on a wall, they're ready to jump 15 feet. That's a provisional sense. You don't have to wait for them to jump. So through that neglect, that Welfare and Institutions Code 5008.2, and now you've got the law, and use it if you need to, but politely. Don't slam it down somebody's throat because they don't care. So, oh, Jim, I'm sorry, I took your slide.
You did a good job.
Oh, thank
That's
you.
fine. No, we're just here to get out the information. We're not here to fight
Yeah.
over slides. It's
Jim and
fun.
I fight over
fun.
not the slides, but over arguments. We have a lot of good debates, and I have learned so much from him, and he's learned from me. He's one of the most wonderful people to work with. I appreciate it.
Oh, you're kind.
Next slide.
Okay, that's mine.
All yours.
Types of LPS conservatorship. You have the LPS conservatorship of the person. And that's where the treating doctor in the hospital initiates this conservatorship with the public guardians. The public guardian then, in turn, petitions the court for the temporary LPS conservatorship and investigates the need for permanent conservatorship. The LPS of the estate would be somebody like Britney Spears, where you would request a conservatorship of the estate through the public guardian's office to ask the court, to waive student loans, court cases, legal papers, help to pay off debts and so forth, and charge cards. There's been cases where individuals owed quite a bit of money, and you just have to step in like this and request that you be conservatorship of the estate, when they are, let's say, running a business, or like Britney Spears she had all of this business going on, money and so forth. In that case, there's a lot of controversy, but conservatorship of the estate is really designed to protect the business and keep it viable until your loved one is stable again to step back into that same business. Next slide.
Well, let me just make a comment since you mentioned Britney Spears.
Huh.
In the state of California, there are two types of conservatorship. One is of the LPS, which is for a person with mental illness, and we told you the ones that would qualify. The other is what they call probate conservatorship,
Right.
which is for everything else with the brain, but not mental illness. Sometimes people will go to attorneys and they pay them thousands of dollars. And the attorney says, yeah, I'll get you the conservatorship. Many times people don't know the difference. So they're talking about a probate conservatorship. They get to court, the judge says the person's got schizophrenia or bipolar. This is not probate, you're in the wrong venue. And they will dismiss the case. Your
Right.
attorney will say to you, I don't know why he did that. He shouldn't have done that. Well, he was in the wrong venue. You have to be in the LPS court. The attorney cannot, he can get the probate conservatorship, but he cannot get, if it's for like Alzheimer's, not schizophrenia, Alzheimer's, autism, stroke, dementia, all that, you can get that conservatorship, probate. If it's mental health, the attorney cannot do it. So don't be paying them money unless you want to. It's up to you. I won't tell you not to, but it is only the treating doctor, the practice is only the treating doctor at the jail or the hospital who can initiate the LPS conservatorship. No one, Department of Mental Health can't make them do it. No one can make them do it, no attorney or anything. And if they think they're going to sue because the doctor hasn't done it, the law says the hospital and doctor, when they release a patient, they are not held liable, criminally or anything otherwise. Crazy, but that's the way it is. So just be careful when you're talking with the attorneys. Know what conservatorship you're looking for. And under LPS, you've got the person in the estate. I'm going to add something on the estate. You request that with the public guardian's office, but if they have a student loan, that you can get that waived where they don't have to pay it off. If they have debts, if they've got some money, you can negotiate with the charge cards, or you can tell the charge cards they have no money, they're under the conservatorship. They might put a judgment. The judgment is only good for 3 years and then it has to be taken off. If you pay even a dime near the end of that 3 years, your 3 years starts counting again. So you want to be careful of that. If you have court cases, legal papers, that would help. Now, Britney Spears, and this is my opinion, did not have an LPS conservatorship. She had a probate conservatorship because she had other problems.
Right.
And, I've heard, not attorneys, but television people talk about, well, Brittany had to ask for money just to go buy a cup of coffee. That is bullcrap. That did not happen. So just to let you know, she didn't have to do that. And your loved one doesn't have to when they're under the LPS conservatorship. People say they take their rights away. No, they give them back their life. So don't buy into that. I'm taking their rights away. You're giving them back their life. Next slide.
Probate conservatorship. Over in the chat, I just saw somebody ask this question. One of the things that Gail and I have a concern about is that there's all this chat going on over on the sidebar, and this is going on meeting after meeting, and we're having all these sidebar conversations. And I just saw somebody say, "Oh, can they get an LPS conservatorship while they're in jail?" We just talked about that. So if you're here to listen to what Gail and I have to present, then please do that. If you want to write a question for us to try to answer at the end of the meeting, we'd be happy to do that. But I'm starting to see questions asked in the sidebar about things that we're covering right here in this presentation. So please, hold off on that if you can. We'll do our best to help you with that at the end of the meeting. I didn't want to say this, but Gail and I have been talking about this, or Sally's been talking about this with us, and we don't want to shut off the sidebar. But just please keep that in mind. So on a probate conservatorship, it's for older.
Jim, I
Yes, ma'am.
appreciate that.
Yeah, well, I'm not shy, Gail, but I want to be respectful of people, and I just want them to understand the problems that we're trying to deal with to help them, and we can't do both. It's either or, So I just have to say it because they're missing what they came to hear. Anyway, for a probate conservatorship, it's for older people who do not have a mental illness. That question was just asked in the sidebar, by the way. It can also be for younger people with other illnesses such as autism, brain damage, stroke, or any brain illness that is not mental illness. Next slide. So conservatives' loss of rights. I was on a Facebook conservator support group the other day, and there was a woman in there that was saying, I'm not going to let my son get onto a LPS conservatorship because they take all the rights away. And I thought, oh, good gravy, come on. There's only a few critical rights that are taken away, and that is temporary. I want to really stress that in this meeting. So the right to terminate conservative loss of rights, the right to right terminated under the LPS conservatorship, the right to refuse medication. Well, the fact that they cannot refuse their medications is the essence of the LPS conservatorship because they have a very serious mental illness. And in that case, it's imperative that we keep them on their medications to help them get back, into reality and back to their normal life for everyday living. The rights can also be terminated to enter into contracts, and that only makes sense to protect them. They can lose the right to drive a car. Understandable if they are in psychosis. Might think there's a elephant to dodge with, and make a sudden turn. They can lose the right, and they do lose the right to possess a gun. Again, these are all very important things. Keep in mind that even though these rights are taken away, things like driving a car can be reinstated during the time that they're under that conservatorship. And I think that's in an upcoming slide. So next slide, please, Araceli. Gail?
Oh, I'm sorry. I was reading something from my son. It's
quite all right.
Anyway, rights of the conservatorship. Your right, if you choose to be the conservator, is to approve or disapprove treatment, placement, and medication. And those are all very important. The treatment, I hate to say it, but there are some quack doctors, just like there's some quack attorneys, or in every field, we all have quacks. But anyway, you can direct the treatment. Now, in a therapy session, you really don't want to know what's going on in that therapy. But if somebody's doing something that doesn't seem right, you can change their treatment program. Placement, this is a big one. You know your loved one the best. So when the doctor says, okay, these are the treatment facilities we're thinking about, you have the power to go and visit those and determine which one is best suited for your loved one. And that's the best thing to do. I'll give you an example. We had a fella that one of the treatment facilities, this kid was brilliant, but he was catatonic schizophrenic, he was mute. And so when the family went to look at the facility, it was for low functioning people. He would have freaked out if he had been there because as the medicine came on, he would be able to talk more. Brilliant kid, but he would have been freaked out. Another facility, because co-occurring, selling drugs across the street. Well, that's really cool. No, that wasn't going to cut it. And the third one, they were packed in like sardines. There were 4 in a room. Your only privacy was if you shower curtain around your bed. And the place was small. He was the kind of person that you're 6 feet away and you're in my space. Why are you in my space? I mean, that kind of thing. So they asked for another set of these were IMDs, Institute for Mental Disease, which is a lockdown treatment facility, to look at, and went toward those and said, yes, there's one that's going to work pretty well for him, and it did. Medications. This is a pet peeve of mine because you have that power on the medications. We had at Silver Lake Hospital, when it was named Silver Lake, one fellow, the doctor had him on 13 psychotropic medications. At the time, I didn't even know we had 13 psychotropics. I don't think we did, but that doctor managed. I called the CEO, checked into it. The doctor was taken off the case. He was titrated down from those medications. He was all over the place because every medication comes with certain side effects, including aspirin. So they titrated him down a whole lot better on that person. And medications, the doctors tend to want to put them on medications that are good for a person who has a mental health problem. Now, please, I am not a doctor, but I've seen this long enough to know they need to up the ante to something for a person with serious mental illness. The difference between if you have a migraine or you have a headache, you don't take Tylenol for your migraine. You have to up that ante if you want to fix your migraine. It's the same with this. So you have the power to approve or disapprove, but you work with the doctor and you do it respectfully. You don't tell the doctor what to do because he's going to say, hey, you're not the doctor, and they're going to shut you out. The doctor has to work with you. Now, you can do it through the social worker with the doctor, but when you want to talk with that doctor, that is your right. Jim, you want to add anything to this?
No, it's just that I've actually had a situation where my conservatee had decompensated, was in a hospital, and they were wanting to transfer him to a hospital in Los Angeles. And I told them that I didn't know anything about the hospital. I would have to go there and determine if that was appropriate for his level of needs. And they about had a cow. Well, how long is that going to take? And I said, only as long as the Welfare Institution Code says that it's necessary. So I will do it as exponentially as possible, but that's just what the Welfare Institution Code says we have the right to do. And so hospitals have a tendency to want to push you around. You want to be respectful, always want to be respectful at the hospital because they are the gatekeeper. But that being said, they don't have the legal right to take your conservatee and just shove them off to some other hospital. They have to first contact you, and you have to approve of that, and you have the right to go to that facility and check it out first. Okay, that's about all I want to add to it. Thank you, Gal.
This is why we're trying to educate you so that these people don't push you around, because believe me, they will. And I'm going to add something about AOT and Care Court. If you have a problem with a team that you're working with, that's working with your loved one, call Venice or call Linda Boyd. Linda and Venice are doing their best to have the best program with great results. And if they don't know there's a problem, they're not going to fire people, but they're going to go back and correct it, which is what it should be. So if somebody tells you something that's not right, call them, let them know what's going on, and they will take care of it because they're training their teams and they are doing the best they can so that everybody gets whatever needs they have covered. And Linda and Venice, I can't say enough good about them. They are amazing people. They really are. And they'll help you in every way they can. Okay, next slide. Just a little sidetrack on that. Who should be the conservator? There are pros and cons of each. And during this conservatorship, you have a year-long conservatorship. If the public guardian's a conservator, they don't have to be it for the whole year. If you're the conservator, you don't have to be it for the whole year. If you start out as conservator and you go, I can't do this, you can request a succession, which can be done in about 7 to 10 days, and it's free. And it can be given back to the public guardian. And if you choose to be conservator, when you are at the court, ask the judge to assign you an attorney. It's a free attorney. So if you have any problems, any questions, you can call that attorney, and ask any questions that you may need. And they will even help you with redoing the conservatorship. Okay, the public guardian. If the public guardian's conservator, the pro is they're able to place the person in a state-approved facility. Now, you don't have the right to say yes or no for this facility, but in Los Angeles, our public guardians are awesome. And they work with you to a certain extent. If you get to be a problem, then they won't work with you anymore. I mean, they don't have time to listen to you on the phone for an hour, so they're not your therapist.
Gail, James
Yes?
Bond raised his hand. I think he'd like to say something.
Oh,
Can we
question?
open up
I
the
just want to
microphone?
clarify, for a private or public conservator, there's not a limitation on where you can go in terms of facility. So I just want to clarify that there's another type of LPS conservatorship called a Murphy that is based on public protection and not necessarily for treatment. A lot of those people go to the Department of State hospitals, but just because you're a private conservator does not mean the type of facility and the quality or depth of facility types are limited in a private conservatorship versus the public guardian. So I just wanted to clarify that point.
Thank
So,
you. That's through the jail, though, if they get it through the incarceration.
If there's
They have,
something where someone's incarcerated, we would not be involved.
right,
So
right,
that's unless you're talking about a diversion program or a incarceration program like a Penal Code 2970 or Penal Code 1026. Well, again, none of those are involving the public guardian, nor should it be involving a public conservator.
right,
So yeah, if anyone's looking at a private conservatorship currently, and that's the decision-making point for you guys, I mean, we encourage our families to keep the private conservatorship if possible, especially because that should not make a difference in the type of facility you can have your loved one go to for their rehabilitation.
right, right. Okay, this is going through the hospital, should you choose to be the conservator. And through the jail you can, but you don't have all the same rights that you would have if they got if they became conserved through the hospital. Okay, going back to the public guardian, the pro is it's less stress for the family. If you have a loved one that likes to push you around and you have difficulty saying no, the public guardian would be a good choice. The negatives, you have less involvement with the recovery process, and you have no control for medication. Now, if there is a problem with the medication, you can talk to the public guardian and ask them if they could ask for a medication review. And that's pretty helpful. They will tend to get that. But work to establish a good relationship for the public guardian. Don't call them every time you turn around. They prefer emailing because if they're out, if their day is out to go out and visit their clients and you're calling them, their interest is in the client, not in what you have to say. So emailing is pretty good. They like that a lot better. Jim, did you want to add anything to this?
no.
Okay, James? Nope. Okay, next slide. Should I be the conservator? The pro is you have direct contact with the doctor, with the treating doctor. And that's the part where you work to find the best medication that works for your loved one. And tomorrow we're going to talk a lot about that. You can reject inappropriate treatment facilities, medication, and treatment places. But you're limited. Keep in mind, you're limited if they got the conservatorship through the jail. You don't always have as much power as you would if they received it through the hospital. The negative is the conservative manipulates you, which is what I said earlier. And the hospital's going to try and push you around and tell you things that aren't true. If they're telling you something that isn't appropriate, you call me right away. And they're going to try to discharge the person to a facility that maybe is not appropriate for the level of treatment that they need. For instance, if your loved one is a flight risk, then they might try and put them in a board and care or a secure facility, and they're going to take off. They need an IMD. If they're not a flight risk, then another facility might be more appropriate. But you want to visit every one of those, and you want to ask about sexual situations in those facilities, because you really don't want to become a grandparent when they go to certain facilities. Okay, next slide.
So the normal process to be transitioned to an LPS conservatorship is that the 5150, the individual is picked up and transported to the hospital. They're put onto a 72-hour hold, and in that interim of time, the doctor determines that individual then does meet criteria for an LPS conservatorship. They are then put onto a 14-day hold. That in turn, while the processes are going between the public guardian, and James, you can jump in here if I'm not covering all of it, but the public guardian's office and county council and the courts all line up schedule-wise. And then the individual is put on a 30-day hold, or what they call a T-con. So anyway, it's very critical. After 4 days on a 14-day hold, a probable cause hearing occurs, which allows the hospital to keep the patient for the 14 days. After the probable cause hearing, the doctor can initiate the LPS with the public guardian's office. 30-day hold, or T-con, the LPS hearing takes place during the 30-day hold. That would be the normal process. James, did you want to smooth anything out that I might have messed up?
No, you're very good, but we'll touch on it a little bit more detail as needed in my section.
Great.
Are we allowed to ask any questions about this normal LPS process while you have the slide up?
Can you write, if you wouldn't mind writing your question down and answer all those at the end, and most likely.
Well, I have to meet them at the hospital in about a half an hour.
Okay, ask away.
What?
Ask away. Go ahead.
My son was picked up for a 5150 and he was put on a 72-hour hold. But after 24 hours, they took him down to the psych floor for a 14-day hold without having him do the 72 hours.
Oh, that's all right. I'm sorry, James. Go ahead.
I didn't want that to happen, because I wanted him to be able to go home to New York. I would like to go through this process, or have him go to a residential facility in New York that's not backed by the state, and they automatically put him on a 50-50. They put him on a 72-hour hold, and in less than 24 hours, they put him on the 14-day hold.
Okay, if I can make a suggestion, would you mind calling James tomorrow to discuss this particular situation, or you can call me?
That's fine.
All right.
Is there anything I can do right away, though?
I think
if I could, can you hear me?
Yes.
Yeah, go ahead, Linda.
Sorry, if I can just respond. We've had this situation happen once before, and it turns out when they put that person on a 14-day hold, it was because they felt like the person wasn't stable. And if you took the person to the airport, particularly given the situation, the way the climate that it is today, if that person, at least in the other case, if that person had acted, they were extremely paranoid, extremely suspicious. If they had acted in any untoward way at that airport, they would have not been allowed to get on the plane. And who knows, depending on what they said.
I won't even be able to get him on an airplane, because he got robbed and his stuff was in a storage unit. He has no ID, no nothing. I sent for his birth certificate.
Okay, so then I think, yeah, talk to the doctors at the hospital and go from there. I just know sometimes when a person's put on a 14-day, it feels like they're just not safe enough to travel. And it puts the client at a great deal of risk going through TSA.
It doesn't
So-
mean that they're not going to let him out after 14 days, does
Oh,
it?
no, of course not. There's no long stay in California for hospitals
So that doesn't
anymore.
mean there isn't anymore. Okay, that's good. They do have it in New York where we're from. They
Oh,
can
yeah,
hold.
no.
So they can't go automatically from a 14-day hold to the 30 hold?
They can. This might be a better conversation if you want to. My number was shown at the beginning of the slide. You may
Okay,
want to
I'll
just
have to
call me
look.
directly.
Where is your number in the chat?
I'll put in the chat in just a second.
Okay, I'm not sure. I don't use Zoom very much, so I just pushed on chat and there's nothing in there.
Oh, okay. Or if you want to put your number in the chat, I'll call you right now. That way, all the other members can go ahead.
Okay, I'm sorry. It's of urgent nature and my friend gave me this information for Gail and then Gail emailed
Yeah.
me and I tried to hop on this. The internet is a little sketchy. Thank
No
you.
worries. I got your
didn't get-
number. I can call you right
Okay,
now.
thank you so much. All right, bye-bye.
No worries.
Thank you, James. Next slide.
Well, during the court hearing, patient's assigned to a public defender. The patient can request a court hearing and have the judge, and as well, the patients can request a jury trial. You want to hope that they don't ask for a jury trial, because oftentimes the people on that trial may not be really up to speed on mental health challenges and so forth. But they have that right, and patients' rights will advise them of this while they're waiting to go, to the court before they get to the court. So they know this. Either the judge can determine whether they'll be placed onto an LPS conservatorship, or they can turn it over to a jury and let them decide. Next slide. Gail?
Oh, the mental health court department A and B, A or B, actually is in Superior Court. It's in Norwalk. That's for LPS hearings and AOT, I believe, and Care Court. Am I correct on that, Linda?
Yes.
Yeah, okay, for all three of those. Incompetency is usually in Hollywood, and criminal court will be whatever court they assign. All right, next slide. After the LPS is granted, the hospital's supposed to hold the patient until a proper facility becomes available. They contact intensive care division and they request an evaluation for the patient. Between the doctor and intensive care, they give a list of facilities for your loved one to go to, and it depends on the level of care that they need at that time. The IMD is the strictest, which is the lockdown. It is not forever. It's just till they get better. The step down is called enhanced residential housing. They have a board and care. This is kind of the levels going down. Sober living or just plain old outpatient treatment. People freak out about IMD. The first time my son was in an IMD, after about a couple weeks, when he was pretty stable, they said I could take him out for 4 hours. Well, let me tell you, 2 hours later, it was returned to sender. Y'all can have him. I really don't want him. But within 2 months to 3 months, we were taking him home 3 nights a week and really hated to take him back because he was just so much himself and delightful. So it's as soon as they are on the road to recovery, they can go to the next level of care. So don't freak out about things. And like I said, people talk about they take their rights away. No, they give them back their life. Next slide. Suggestions for recovery. Remember what your loved one was prior to their illness. My suggestion is seek that level of recovery. And when they're still doing poorly and they're getting visuals or they're hearing voices, think about their medication. Work with the doctor on possibly trying something different. What medication works for one doesn't necessarily work for another. And you want to find the right medication that works for them because you want them to be able to get their life back. And believe me, with the right medication, it's very rare when somebody doesn't. So you want to do that. You want therapy, cognitive therapy, addiction treatment if they need that. This is the time to talk about addiction therapy. Next slide. Take that family to family class. It's free. Some places, many NAMIs offer it on Zoom. It's nationwide. If you take it in New York or, wherever, it's pretty much the same thing. It's a good program to help empower you with knowledge, and they have a great section on medication. Join NAMI, get involved, vote. Whatever you do, call the people and find out where they stand on mental health. That's really important. Next slide.
So, yeah, we recommend that you keep 2 journals. One is for your loved one, and one is for everyone that you speak with, and to keep a sense of humor. The journals are really, really important. I was very impressed with the family just yesterday, in fact, because in talking to her, found out that she'd been keeping all these journals, who she talked to, the medications, all of that. And so very, very important that you keep journals on all the phone calls that you make, the people you talk to, and so forth, and should have a journal also on the medications, I might add, and which ones seem to help the most. And keep a sense of humor. It is so devastating. No one's immune from the kind of impact that occurs when our loved ones decompensate, and we're concerned about their well-being, concerned about their safety. So stay in tune with the Department of Mental Health, Gail, myself, James Kwan, Linda. There's no other person that's as wonderful as Linda, and so helpful. But keep your journals, keep your sense of humor too. You have to stay strong. If you get weak and you get depressed, you're not going to be able to help your loved one that well. Next slide.
Wait, I'd like to add something on this.
Please. Sure.
When you're keeping the journal for your loved one, and that's like what medications, things that they're saying, my suggestion would be not to correct what they're saying, because you don't want them to clam up and stop telling you things.
Yeah.
Because that's the only way you're going to know where their mind is at. So if they say something that's really weird, you can say to them, wow, that's got to make you feel uncomfortable. I don't see it that way. You can do that. Or I just don't see it that way. How can I help you with this, or something like that? But be sure it's something you could help them with. Even when they're recovering, don't say, well, that's not true. That didn't happen. Because you want to know where their thinking is at all time. And as long as you've got that communication, that's very important. My husband and my son will tell him everything. He won't meet to me because I was a bad cop. My husband's a good cop. And I'm the one got him in the hospital or whatever needed to be done. And we did it that way, so we knew where he was at all times. So keep that communication open as much as you can. And like Jim says, those journals are vital. Everyone you talk to, you've got to get their conversation, what they say, everything. Okay, next slide.
Could I just say one more thing, and that is, there was a dad who felt that his ex-wife was not capable of providing the mental health care for his loved one. He is out of state. So he brought his son here to California. And in the time that he was here with his new family and new wife, his stepmother, he got in an argument with his sister or half-sister, and he stabbed her with a knife. Later, after all of that, the doctor shared with the father that he almost wasn't able to save the daughter's life. And that really did something to the father's mind in regards to his son. He says, I can't help it. I don't feel the same way about him after, learning that I almost lost my daughter. And what I have to say about that is, remember that what you're looking at in these type of behaviors is the mental illness, that person needs continued support, needs your love, needs your compassion, needs your understanding. Stay strong, stay connected to NAMI, for your own health. But just understand that when these things happen, that, those are not events that need to kind of turn off your feelings. You know, you do need to keep a sense of humor. All right, next slide. So I want to make one comment. You know, we've never made comments. I think this is one more slide after this, if I'm not mistaken. I think one more photograph. We all see individuals like this gentleman standing at our intersections, have a little cardboard sign up, you know, need help, I'm hungry. What I'll share with you is that there was an individual, the mother called me from, through various connections around the state or the country. Mother called me from Arizona. Her son, she knew, was out here in my area and wanted me to assist in finding him. And I helped facilitate that through various police departments. The bottom line is that her son has 2 degrees in biomedical engineering, smarter than anybody in this room. I'm sorry, incredibly brilliant, but he's also mentally ill, lived with filthy clothes, you know, the cardboard sign. So when you see somebody out there with that cardboard sign, that's somebody's son or daughter that's out there. And remember that, you know, it's the mental illness that put them there and they need our help. Okay, we're done, I think.
Jim,
One
yeah,
more slide.
yeah. If you all can donate. Oh, Jim, that's one. that
No,
you-
it's good. I think that's G down there.
Jim,
That's okay.
this slide.
She always pins this one. It's like pin the tail on the donkey. Oh my. So just remember, I'm my brother's keeper. You know, we put these on for everybody. And we are asking for your assistance in helping us to continue these classes and donate what you can to keep them viable. And this is an address that you can send your donations to. And Gail and I both say, gosh, you know, if you're living off Social Security or you've got bills up, you know, just drowning, please don't contribute anything. We're not here only if you're in a position to donate.
Yeah, we would appreciate the donations, but if you're not, please don't.
And if you can, let them know that your that check that you're going to mail in would be designated for the LPS classes.
Yes,
So
I'd be grateful for this.
we
All
would
right.
appreciate that.
Thank you.
James, I think your microphone might be on.
James, you with us?
Maybe he's having a conversation with that lady who needed immediate
Oh.
help.
That could be.
Okay, Linda, do you want to go ahead and take it then for AOT and then we'll get back to James?
For care. So you want Venus to go first
Care,
with
care.
AOT?
I'm sorry, Care.
Or would you like care first? Whichever you want.
Yeah, whichever, it doesn't matter to me, either one.
Venus, your choice.
The original order is care, so do you want to go? So I don't mind.
Sure, sure. Yeah, go ahead and I think Venus should go because it's LPS is the most restrictive, care is the AOT a little less restrictive, and then care is a little less restricted than that. So it might make more sense to do it that way. Yeah. Thank you, Araceli. It's all yours, Venus.
Let me unmute on the video. Okay, thank you. So good afternoon all. My name is Venus and my last name is a little bit difficult to pronounce. It's called Ngai, but anyway, it's okay. So I'm the program manager for the AOT. You know, I've been picking up the baton from our dear Linda for almost 8 months, 9 months. I used to with AOT, but now come back and have been learning a lot from Linda, but it's okay. So she know a lot about the everything about AOT, care God. So we collaborate a lot. So it doesn't matter, I think. So today I want to talk about AOT. So you may, for the participant, you may have already heard about AOT. It may not be your first time. It doesn't matter your first time coming to this workshop or not. So I try to provide a general introduction, but also want to highlight the areas that AOT, the families or friends may be interested in and also important to know. Next slide, please. As you can see, the picture of Laura Wilcox. And last May, the May 2025, in fact, is AOT 10-year anniversary. So AOT LA has been for 10 years. And 24 years ago in 2001, and then the 19-year-old Laura Wilcox is still a college student. And she was helping out as a receptionist in an outpatient mental health clinic. And during her winter break, and she is helping, she was shot to death by individuals suffering with severe mental illness. And to make a long story short, as a result of the incident, Laura's Law, officially known as Assisted Outpatient Treatment Demonstration Project, was implemented. Next slide, please. So this legislation allows LA County or the other county who participate in this AOT program to use the court system, the court process, to order individuals who have severe mental illness and have a history of non-compliance and at risk for deterioration or harm, and as a result of poor poor treatment compliance, into outpatient treatment. If they pose a risk to themselves or the other and unwilling and don't want anything, don't want to participate voluntarily into treatment. And the main goal of AOT is to link client to outpatient treatment. And we talking about two type of outpatient treatment. So here I highlight in red, the first type is called full service partnership. So we also call it FSP. Full service partnership is a field-based wrap-around program and have a multidisciplinary mental health professional and to try to provide a whole array of services. And I can talk a little bit more later. And we don't have a lot of individuals being linked, but it's also an option called Enriched Residential Services, aka ERS. Even though there's a word called residential, but it's not inpatient. It's just a intensive mental health treatment with a housing component. And at Department of Mental Health, both the FSP and ERS are operated by county contracted provider. So basically they're not operated, those providers, service providers or treatment provider are not operated by DMH. Next slide, please. So if individual continue to refuse services, AOT LA can opt to petition individual to the mental health court, the AOT court, and so that the individual can be ordered to the psychiatric outpatient treatment program, just like what I mentioned, the FSP or ERS. And of course, hopefully through this process, through the outreach engagement, we try to solicit the individual want to voluntarily participate in the treatment, but if there's really not working, so they have the option about the petition. And this AOT LA program expand the interagency collaboration with the mental health court, the county council, the public defender, the Independent Defense Counsel Office, we also call ECHO, Patient Rights, and the local law enforcement. Next slide, please. This slide seems a lot of information, but I think it's very important. And we talk about AOT, the criteria for the individual who can accept to the program is pretty specific. You can see there's 7 bullet points, and I will spend a little bit more time for certain bullet points. And for the first one, individual have to be 18 years old, cannot be 17, cannot be 17 and a half. So once in a while, we get an individual just maybe 17 and 10 months old. So then at that moment, we still cannot accept the individual. An individual have to have a severe and serious mental illness and a DSM treatable diagnosis. And we know we have a lot of individuals who have also substance abuse disorder, co-occurring, but we mainly are treating the, we are talking about clients have the DSM diagnosis. For example, we commonly see a lot of schizophrenia, bipolar. Sometimes we see people have post-traumatic stress disorder, but the schizophrenia or psychotic disorder is a very common diagnosis among individuals accepted to AOT. And I would like to spend a little bit of time about the third bullet point, the history of non-compliance with treatment, that results in one of the following. We always say this is an objective criteria because it's something that it's not really up, it's not a lot up to your interpretation. The first one we talk about have 2 or more psychiatric hospitalization or forensic mental health episode within the last 36 months. So we are talking about psychiatric, for example, college, Long Beach they have their medical unit, but we are not talking about an individual admitted to a medical unit, but have to be psychiatric unit. We talk about individual not only in jail, but have to be in forensic episode, as we can see from the medical record. And we know that there's a lot of individual, they demonstrate violent behavior, have ad and threat, but they are not hospitalized due to various reasons. And at this moment, I think I would say that one of the objective criteria is the individual may demonstrate 1 or more act, threat, or attempt to cause serious physical harm to self or others within the last 48 months. I'm not saying that I can be exhaustive, give you a list, but I want to, in general, talk about some of the examples that we see. We always see in the referral that we will be able to accept. For example, punching a family member with a fist on the head, push someone forcefully on the floor and keep kicking. The threat is, for example, threaten to, with a viable mean like, I'm going to cut off your head with a knife, and I'm going usually we see someone say going to shoot you, but the individual may not have an firearm. We also see attempt that in the demonstrating some of the individual, the referral, we see that individual attempt by hanging, put a knife across the neck, or they attempt in the past episode that they attempt to jump off a bridge or jump off a cliff. And in the end, I would say usually we will ask if there's someone who is able to witness the act. For example, if your individual is really attempt to hang, do you see the action or do you see what's going on? Or you're the one who being abused, physically attacked, will you be willing to testify? Because it's something that if down the line, we have to really go to the petition process. Individual have to, the witness or the victim have to be able to testify in the court to support in the petition process. Another point I would like to say, elaborate is about the 4 bullet points, clinical determination based on treatment history and current behavior, at least one of the following. The first point is unlikely to survive safely without supervision and is substantially deteriorating, or in need of AOT-LA to prevent relapse or deterioration, likely to lead to grave disability, harm to self or others. We know that, a lot of individuals, your loved one have mental illness. Some may have already struggled for a long time. They may have a big drop in functioning, from being able to graduate, have a stable job to now maybe homeless or maybe really struggling. I know that there is a big drop in deterioration, but we want to look into the past, just like the previous paragraph, the past 3 to 4 years. What is the significant deterioration? Is there any hospitalization, psychiatric hospitalization, arrest, police call, disturbance of the neighborhood, going to be evicted? So not just normal, it's not regular functional deterioration about losing a job, but any more severe causing harm to self or the other or the community. So this is something that we always run into a little bit discussion, even among the team, the referral team. I mean, the referral review committee. The fifth bullet point, we talk about failure to engage in treatment. In AOT, our criteria is pretty strict. So if individual is in treatment, for example, seeing a psychiatrist but not taking a medication. We cannot accept individual. It sounds pretty harsh because we know that individual with severe mental illness, medication is the first line. You know, as Gail mentioned, you have to have a chemical imbalance. You need medication. But in AOT, we have to be the individual fail to engage in any form of treatment. And medication AOT does not have the right, does not have the authority to force someone to take medication, which I will elaborate a little bit later. So if someone is in psychotherapy, so not really seeing psychiatrists, not taking medication, can we accept kind in the individual in the treatment into AOT? Or someone is really seeing a psychotherapist consistently, but really not talking about anything important to learn any coping skill, is still deteriorating. So all this, I would say, feel free to contact us to consult. I received call that Gail referred someone to talk to me, or individual called AOT General Hotline, the line number, and then transfer with me, and then we individually talk about the case. And a lot of time, I will also review the referral and then provide further advice about individual referral as well. And AOT have to be the sixth bullet point talk about AOT, the least restrictive. That means for example, the individual can function in the outpatient clinic or can function in the full service partnership. So AOT have to be a little bit higher level than that. If you can function at a lower level, we are not going to have to force you to do a higher level of care like AOT LA. Or if the individual is fine, gravely disabled, going to be in LPS conservatorship, then they need a higher level of care. AOT LA is not a suitable level of care for individual. And the last result list is that we have to see.
Oh, nice, thank you.
And also we have to see the last bullet point is that the individual have to be likely to benefit from AOT. Through experience, we find some individual who really, due to their presentation, they are not able to benefit from AOT. Can be because their presentation, their acuity of their mental illness, or due to even they are not really, the court process is able to benefit, they are not really respecting or following, even they go through a court process. Next slide, please. Next slide. I'm sorry about that. Yeah, who can refer? I think in this NAMI meeting, I think workshop, I think the first two bullet points are maybe the most relevant. So I will spend a little bit more time to elaborate the first two category of referral party. The first one is the someone who live together with individual you want to refer, 18 and above. It can be roommate, fiance, boyfriend, girlfriend, niece, cousin, friend, anyone adult living together. But a lot of the situation, we have also family member. Think about you, your loved one. You want to live with your loved one. But AOD only for close relative, we only allow parents, siblings, spouse, or adult children. For example, if you are a friend or you are the cousin or niece, you want to refer, but you're not living together. So what can you do? So you can later on we'll have a referral form. We have show you some sample that you put, for example, individual, the parent, to be the one who the name of the referral party, but you can be the one who assists in complete the referral form. So later on we'll post up the referral form. We can show you a little bit details. And the other major source of referral for AOT-LA is a licensed mental health treatment provider who treat or supervise the treatment of the individual. A lot of the referral we receive is from current treatment provider. For example, your beloved maybe go to Compton Mental Health, go to Sycamore, I just name a few, but they are not really doing the treatment and deteriorating. So you can ask the mental health professional who's seeing your beloved to complete an AOT referral. Or due to a crisis, you call the Department of Mental Health, the psychiatric mobile response team, the one who come to place your loved one into a psychiatric hold to the hospital. They can also have capability to complete the AOT-LA referral. And we have a lot of within DMH, they pretty much is also a significant source of referral of individual. They see individual really have an act of violence, or they get repeatedly hospitalized and refer the individual to AOT-LA. So, and also, of course, one of the other, we see other referral, and one of the referral I would say we receive from who are not eligible. For example, mental health administration, insurance company, apartment manager, housing program. They are not the according to all the category here, they may not be the qualified referral party. So when we receive the referral, we will discuss with them. Do you have contact with the family? Can you talk to the family member? The referral form, instead of using your name, have the family member name, the mom, the daughter, to be the name of the qualified referring party, but you are the one who complete the form. So if you receive a call from someone who say want you to refer your loved one to the AOTLA, so I think maybe it's the moment that hopefully you will consider doing that too. Next slide, please. Here's the process of the AOTLA process. And I'm going to go through the last three process, but when an AOT received a referral through mostly sent to our AOT general email, and then we will have staff to review the medical record available, including the DMH record, the Department of Health Service record, a jail record, whatever we can available, even including the list, the information that the family member provide can be the history of hospitalization, diagnosis that Gail asked you guys to prepare. Those are very useful as well. And we'll get call the referral party or concerned parties to try to gather information to determine whether an individual is eligible. The case are presented at our weekly AOT referral review committee. If the referral is accepted, so of course, if the referral is not accepted, we will notify the referral party that due to what reason the referral is not accepted, how can you make it to be accepted if possible? And then if the referral is accepted, and then I just want to say that it is not something that we AOT will immediately available to provide treatment. So we have a lot of individuals just send a referral thinking, okay, my son or my daughter is going to release from the hospital. Can you send a referral? Can you find a placement for individual? So AOT is not someone that individually can provide or start treatment, because according to the statute, we have to 30 days of outreach engagement, which means for those who refuse treatment, we have to allow a chance to visit them, meet with them at the home, at the bar and care home, at the street where they are, hospital and jail, and try to solicit they want to participate in the treatment on a voluntary basis. We provide psychoeducation and support to the family. We explain about the AOT program, the process, and discuss safety plan. And I want to say family involvement in this process is very, very important, because a lot of individuals may be living with family, and we need you to work with the team, the outreach engagement team, to provide access to the individual. Or if the individual is homeless, is unhoused, how about unhoused or transient? The family member may know how to locate individual for the AOT outreach engagement team to locate and make the face-to-face contact. So you are the pretty much the gate allow the AOT to reach the individual. So AOT will work closely with the family, and also at the same time, we will also work closely with the law enforcement regarding safety. We work with hospital, we work with jail linkage, we work with a lot of collaborator parties, and we really think of the box how we can arrange link the client to treatment, to FSP level or ERS level of treatment. So if individual refuse treatment, then AOT may will review whether at that moment whether individual meet AOT criteria, the 7-point criteria that we just mentioned, and there will be continued assessment and for criteria and also for safety. If AOT determined that, okay, we really need to petition the individual to the AOT court to order for treatment, so then we'll go through the process. But I want to mention that there will be, it's a civil court, it's really not a criminal court. So it's not, there's not LPS conservatorship, there's no forced medication. So basically we see individual who is able to keep saying no, we use the court process. Hopefully we'll be able, individual respect or trust, or through the judge tell you you have to participate in this treatment regimen. You have to work with the treatment provider. You are coming back and report the progress, how you're doing. Hopefully the individual will be benefit from this process and finally be compliant and participate in the treatment. So the individual who is petitioned, they will appear in front of the court, can be in person or now through the online, we call LA Court Connect, the platform. The initial order treatment is 6 months, but can be extended to another 6 months. And in the individual is really not doing well, not stable, the judge can, and the AOT can opt to extend the petition. We do have a lot of individual that finally graduate, finish the 6 months, don't need the court component and continue to voluntarily stay in the AOT treatment. I can see individuals stay for 1 year, 2 years, and some even graduate and move to even lower level of care than FSP, move to an outpatient level of treatment. But we also have some that need extension because they really continue to struggle through the initial 6 months of treatment. And we also even have someone that initially say, yes, I want to participate, and later on change their mind. And then they are linked to FSP, but we still need to bring them back and petition them. So there's a rarest shade, rarest form, but I would like to say that I can see there's a successful story that later on I can share with you all. Next slide, please. So now it's up to a point I would like to say what AOT is or AOT does and what AOT does not. I would like to say for AOT, we talk about the one in this continuum, conservatorship is the most restrictive because clients at LPS, they're conserved. The conservator have to determine whether they take medication or placement. But on the other hand is, that they can be in a open setting, you know, just like they totally voluntary. They can decide to disagree to the treatment. They will tell you that I'm not sick, you are sick. This is my house, it's not your house, and you know, just causing a lot of trouble. We see a lot in this continuum. So AOT allow that somehow in an option for individual who refuse treatment. But we try to, through the outreach engagement and the petition, to be able to solicit that participate in the treatment, and they finally, through the court process, they choose to agree and finally be able to engage. But of course, as I mentioned, we still have processed individual that not choose to, or just really we are not able to engage, and we have to dismiss the petition. There's a case like that too. And the main purpose is that we hope that through this process, we can prevent violence, for example, prevent any crime, prevents victimization, hopefully prevent individual from being arrested, put in jail, arrest, or hospital. But of course, I think if the individual is unstable, really need to, I think, of course, we always say have to call the Department of Mental Health, the access number to hospitalize individual for stabilization. But we hope that by doing this outreach engagement and link individual to the FSP, we are able to intervene before the individual reach the level that need to be hospitalized. It's not about the imminent risk. We see the individual is deteriorating. So hopefully we are able to intervene ahead of, not ahead, but beforehand. And we also hope that, as I mentioned, use the court process, use the judge order you, and judge through the progress hearing will talk to you so that the individual will be finally be able to agree to treatment and participate in treatment. And as I mentioned, AOT is strictly voluntary. So individual can continue to refuse to take medication, refuse to engage in court order treatment, and there's no civil and criminal penalties. We do see some really difficult case that finally through continue to bring them back, and they finally really comply the treatment. Somebody that really homeless and really the home team, the med team, hospital, a lot of partners that really have problem getting individual, and through AOT, very persistent outreach engagement and the process get finally client graduate. Just like I mentioned a few years ago, it's a case that everybody really have a headache. I returned to AOT, I find the individual finally graduate from AOT. So this is very unbelievable to me, but I want to say that seems at that moment everybody kind of losing hope, but you can see that sometimes things is possible, but it's just really a difficult process and need a lot of collaboration from different parties. Next slide, please. I also want to clarify some misconception of AOT. So as mentioned, AOT is not conservatorship, and it's not a must that will lead to conservatorship. Even though we see individuals that really gravely disabled or really need to be conserved, we will try whatever way that we advocate for conservatorship, no matter in the jail or the hospital. But it doesn't mean that AOT can definitely lead to conservatorship. And also, AOT doesn't have the authority to mandate involuntary long-term hospitalization. We cannot say the hospital, please hold someone for long-term hospitalization. But when we see individual really, really mentally unstable, you always advocate to the hospital to please keep the client longer for enough stabilization. And we always advocate if the individual can benefit from a long-acting injectable, so we always will do that. As I mentioned, also AOT is not someone that once we accept that we are able to provide treatment, because we have to have a period of 30-day outreach and engagement. And then we will, but if individual, the first time we meet with them, individual want treatment, we will immediately start the process to link them to the FSP treatment provider. And also, as mentioned, AOT is not something, a program that immediately someone going to leave the hospital or release from a jail or immediately can provide housing. Housing is not something, it's available, treatment provider to have different treatment option, shelter, boarding care home, different housing, but it's really not something that immediate. It really depends on individual where they want to go, the status or the income. There's a lot of factors to determine, but if someone is willing, the provider always would work their best to try to link individual to housing and the other benefit as well. And we are also not a program that respond to crisis, or family member may sometimes expect we will respond to call, immediately. For example, individual come home at 10 p.m. Can you come right now? Or individual really in a crisis. I would say that for crisis, the better to contact Department of Mental Health, because Department of Mental Health SS is 24/7, and we do have 24/7 crisis response team. And also we try our best to reach out to individual. We know the family member may work or may have a certain time that's more available to provide access to individual. We always try our best, but I think it's a process, so that's why it will be a very close collaboration with the family member as well. And we cannot mandate or we cannot force medication, as I mentioned. Next slide, please. Here, I think it's a new, the most updated AOT referral form. If the referral form that you have doesn't look like this, disregard all the red square or green square, then that means the form on your hand may be outdated. You can always go to the AOT webpage to download a copy of the AOT referral form. Here, I want to put an example like on the left. The top part of the referral is about a referral party. So the name will be on the second part. The individual you want to refer, your loved one, will be the candidate information, the second part. But the top part, I'm talking about the referral party. For example, Jane Doe is someone, for example, is a sibling. So of an individual you want to refer. Then it's a qualifying referral party. But in fact, it's John Doe is the son of the referral party who complete this referral form. And the individual, in fact, is living in the apartment by himself or herself. So that's why I think you want to also put down if individual live by itself, or in apartment, you need somebody to contact to get access. You may want to put down the information as well. In this situation, maybe the apartment manager. So next slide, please. I think almost close to the end of my presentation. I think I always like to offer this. There's always hope. I really want to instill that. And first is a very close collaboration among a lot of partners. So individual referrer cannot be able to link the treatment or be able to success without a lot of partners. Just to name a few, law enforcement, we can have the sheriff, the LAPD, we have individual city police, and then we have med team, and they all refer to AOT. And we also talk about all this partner, for example, hospital liaison, jail liaison. We have a lot of parties work together. We share information. We all have it to share information to see what is the best strategic direction for a case, how we move individual towards the treatment. We also work closely with law enforcement, talk about execute a 5346 hospitalization order. Sorry. And also, I think throughout this process, I think everybody consult, and also individual, for example, FSP provider, they will consult AOT, or we have meeting with individual like the crisis team to consult on cases, what will be the best direction or what should we do for individual. So I can't emphasize less on a collaboration. But the second most important thing I want to highlight for those who in this workshop is about family involvement. I really believe deep down, really believe that family is the hero. For us, the professional, we may see individual 1 or 2 hours per week, or even on a crisis call, a few hours. But if you live with your loved one, you are 24/7. Even though you're not living with your loved one, guess what? They're always on your heart. And you come to the meeting here today because you have someone that you really care for. So you want to know how to get them help. So without you guys, we won't be able to get access, and we won't be able to move the case along. So I always say psychoeducation, provide information, resources, linkage, always a very important process to get the family involvement. So I think there's quite a few success story still stay in my heart. I think even long time ago, every story do really remind me. I remember Linda and I talked about a couple of cases. We all get a little bit watery eye. And in fact, to Friday yesterday, very fresh the memory. We have a father who come to AOT testify as a witness about an act of violence his son bring on him. And I cannot disclose the details, but the way he presented the case in front of the judge and then plead to AOT, please help his son. And at the end of his testify, no single one in the room has dry eyes. It's just very touching the way, not only about he presenting, it's about the desperation, and he really wants the son to get the help. And from that case, I know that there's still a lot of challenge ahead. I can see literally the challenge step by step, but I can see it's the first step, and there's always hope. We just take it one step at one time and work together with family. I think the family have been living in that situation for a very long time. We come to an end that really very desperate. So I want to say that it's not a definite answer as say AOT is the answer, but definitely I think there's some hope for how that we want to offer the hope. The last but not least, I want to put down the information is that always, if there are crisis, you should always call the 24/7 AOT helpline, and here's the phone number and the AOT general line number. And you can always email us, for example, the AOT referral form, and you have the AOT LA webpage that you get the referral form or the brochure, and below is my contact. Okay, here's today for my presentation, and thank you so much.
My name is James. My name is James Kwan. I'm the Deputy Director here at the Office of the Public Guardian at the Department of Mental Health in LA County. And Gail and Jim do a fantastic job going over conservatorship. So we're actually going to zoom through a lot of these. But one of the things that I wanted to touch on were the two types of conservatorships that you may see being talked about frequently in forums and other other settings. So if we can go forward, one more slide. You guys know what a conservatorship is. But there are two main types of conservatorships that are used in California. There's a third there. I'm gonna just ask you to ignore it because no one's ever really asked about that one, but that is for someone who has a developmental disability, um, and that the family may want to provide for them in the long run. But the first two you see here are probate and LPS, which is why you're here. And I kind of want to go over the differences between the two so that we can be clear on what you and your family's needs may be. So as you know, an LPS conservatorship is based on the term grave disability, which we will discuss more. But if you don't meet that grave disability, which again, I think people have sometimes wildly differing understanding of what grave disability is, so we will touch on that. But if you don't have a grave disability due to a mental illness, then you would not be able to petition to become an LPS conservator. Probate, on the other hand, is a conservatorship that's based on cognitive impairments, more specifically, a major neurocognitive disorder. And what's more, used to be what most of what the people who were on probate conservatorships were put on were due to dementia, a symptom typically of Alzheimer's, but several other diseases. And this would progressively render them unable to make decisions for themselves. So this is based on cognitive impairments that do not improve. And that's one of the biggest differences is a probate conservatorship. Typically, there's not a prognosis where someone's going to improve. So a probate conservatorship is maintained through the lifetime of a person. You do not become terminated or dismissed from a probate conservatorship unless the court takes active action. An LPS conservatorship, on the other hand, terminates at the end of a year if you do not reapply for an appointment. And so we can go over that as well. But that's one of the biggest differences. Again, probate lifetime appointment for the conservator, right? And then LPS, you have to renew every year. One of the other things that probate does not allow you to do is you cannot involuntarily medicate somebody, especially involuntarily medicate somebody with psychiatric medication. You can consent to you can consent to an order for psychiatric medication for someone who's on a probate conservatorship, right? But if they protest that, you cannot involuntarily force them to take psychiatric meds, nor can you involuntarily commit them to a locked psychiatric facility. So those are the two main elements that Gail and Jim were very clear on in their presentation about the use of LPS is the use of medication and treatment, if needed involuntarily, to get someone back to their baseline, and the use of a locked setting to ensure that the person remains stable and does not run off during their treatment. So probate does not give you any of those powers. Probate, what that allows for is long-term physical care for somebody who's not necessarily going to improve their mental state, cognitive state. Very few young people get put on probate conservatorships. One of the other big differences for probate and LPS is that anyone can apply or petition the court to become the probate conservator. So the Office of the Public Guardian in LA County receives about 1,900 to 1,600 probate referrals every year. But even outside of that, there are tens of courts in the Stanley Moss Courthouse where they do probate matters. That's because anyone can petition to become a probate conservator, not just a public guardian. Typically, the public guardian gets probate referrals in situations where no one else can act, and they're referrals from parties that are like more public, whether it be banks, hospitals, nursing homes, adult protective services, and the like. Sometimes also from DMH. On the other hand, the Office of the Public Guardian is the sole investigator for all LPS referrals in LA County. I'm sorry, all counties in California have a designated LPS conservatorship investigator, whether it's housed in the Office of the Public Guardian of that county or within behavioral or mental health within that county. Only the public guardian can initiate an investigation based on a referral, and the referral is typically from two sources, either a designated facility, which you guys would see as an acute psychiatric hospital or an acute hospital, or the courts, the mental health courts or the jail, right? Those are the two main sources. So no a private person on the street can just petition to become the LPS conservator. What typically happens when we receive a referral is that during the investigation, or if a family member is very proactive, they'll call us in advance because they know that a referral is coming to us, that they want to be involved, and the Office of the Public Guardian will investigate to see if someone is gravely disabled, does meet the standards for an LPS conservatorship, and then also if that particular family member is suitable to serve as the private conservator. We very much encourage our families to be involved. I mean, I don't think there's anyone in DMH who would say families don't get involved. I know that Jim and Gail put out some reasons where you may not necessarily want to be the conservator, but you still want to be involved in the treatment, and we respect that. The appointment of a private conservator is not mandatory. So you guys don't have to feel a certain way about wanting to be involved but not wanting to be the conservator. That's what we're here for if you need. But oftentimes families do choose to want to be the private conservator. And then what happens is typically at that hearing where we meet to discuss the conservatorship, if it's not contested, we will also recommend to the court to appoint the private conservator, which could be you as the family member, and then you would be given those powers that Jim and Gail mentioned. Some of the other things that LPS cannot do that probate does is, on a probate conservatorship, you can consent to medical treatment. On an LPS conservatorship, you can only consent to what you would call routine medical treatment, which is like going to the doctor for a checkup. But if it's anything specific, let's say like you got a diagnosis and you have heart disease and you need a uh, uh, open transplant, like open heart surgery, sorry. We would not be able to consent to that immediately. We would need to get a doctor declaring that the LPS conservatee is unable to consent to this because they don't have capacity to give informed consent. We would need to do a bunch of paperwork to petition the court to allow us to consent to this, which becomes a little bit of a process, but that's one of the other differences in the powers between a probate and LPS conservatorship. Let's move on to the next slide. Just again, reminders. So when you see the slides, probate conservatorships, lifetime. LPS, duration is 1 year. And probate conservatorships, anyone can petition. So if there's a situation where you may feel like your loved one needs a probate conservatorship because they have a degenerative neurocognitive disease, that may be appropriate. One of the other differences is there are two mental health courts, as Jim and Gail mentioned. There are two LPS conservatorship courts in LA County. They're both housed at the Norwalk Courthouse, and they both hear LPS conservatorship matters as well as care court and AOT matters. But probate conservatorships could be almost any courtroom that handles a probate matter at the Stanley Moss Courthouse. One of the other things is LPS has a pretty strict 30-day-ish timeline to get that first hearing for the LPS conservatorship, whereas probate conservatorship, if you can petition and it may take you 3 to 4 months to get a hearing. If you filed on Monday, they may not have a court date for you until 3 to 4 months out. And then if you cannot prove the incapacity of that person at that hearing, it may get continued out 3 months at a time. Rarely do they continue it out 2 weeks, 1 week at a time, like they may do in LPS court, because those courts are heavily impacted. So that's the timeline for probate conservatorship. The one other thing with probate conservatorship versus LPS is, again, this is for the protection of typically vulnerable elderly dependent adults that are not going to reconstitute or improve. And that means they have a very stringent standard. So in LPS, you have grave disability. In probate, they call it capacity, and they utilize what you call a capacity declaration, which is it's a judicial form that a doctor that has 5 or more years of Jerry psych experience would fill out about their experience and understanding of the decline of the person. So they go way back into the history of how that person's capacity has been declining. And so typically from what we see, that's a much higher bar to get to than grave disability, which has a much simpler, as at least for now, a food, clothing, and shelter, and the inability to provide for that food, clothing, and shelter due to mental health uh, uh, illness. So those are the two different ways that you would justify putting someone on a conservatorship, whether it be probate or LPS. And getting a capacity declaration is typically much more challenging because you need to have a doctor that potentially has seen your loved one for the past, 3, 4, 5 years and can attest to that in a trial. Let's move on to the next slide. So again, anyone can initiate the process, and these are the areas where we typically get referrals from. One more forward, please. I think we went over a lot of these, but again, oh, sorry. One more slide forward, please. There we go. So just going over the series of holds, where we would typically see referrals from our hospitals, and those holds are in place to give intensive treatment. So I just want to kind of highlight what the severity of what a conservatorship means. I know that everyone's here, or a lot of people are here on the call to see if their loved one is appropriate for an LPS conservatorship, or you've already kind of made up your mind that your loved one needs LPS conservatorship. But a lot of times what happens is during the holds, someone's receiving intensive treatment and they end up reconstituting to the point where they can make a very personal and real case for their lack of grave disability. And I know that's the challenge for a lot of families, where they see people cycle through these systems because they're getting just enough treatment to get better. And then legally, the term grave disability, if they can demonstrate that they can provide for their own food, clothing, and shelter, and that whether or not they have a mental illness, they can provide for that. Legally, they're no longer considered gravely disabled. So some of you may have had experience where a hospital, whether it be that during the 14-day hold or the 30-day hold, someone was released. It could be the case that they won their certification hearing, or they won a writ hearing, a writ of habeas corpus during that time, and that the hospital had to release them because they were no longer gravely disabled. Let's move on to the next part. Oh, sorry, we don't have to go back to the last slide, but again, initially LPS was created so that it would stop the, involuntary, I guess at that point in time, commitment of people into the state hospital system without any due process. So they built a system where they got rid of that nilly-willy incarceration process, commitment process, and gave everyone due process, where they can have processed during that involuntary commitment period, but they never really fully fleshed out where they would go if people were found to be gravely disabled or really sick due to a mental health issue. And that's some of the price that we pay currently, in that the system around the state hasn't quite caught up to what the law was not designed to do back in 1967, which is give people the ability to contest their psychiatric commitment. Let's sorry, we can stay on the slide. So, like I said, there's two sources where we can receive referrals, and designated facilities. There's a lot of acute psychiatric hospitals. There's a lot of just general hospitals that have psychiatric wings, and those facilities will go through the typical hold process, right? 5150, 5250, and the 5270, up to typically 47 days worth of holds, where they can get treatment for that period of time. Another source where we receive referrals from is the court, where people are not competent to stand trial. So if you're not competent to stand trial, obviously you can't have a trial based on the merits of the case, because you cannot participate in your own defense. And sometimes they'll get sent to a program where they're given mental health treatment to see if they can be restored to competency. Oftentimes they're not able to, and they're returned back. And then they go through a process where then they could be referred to any of our three programs here if they're not referred to diversion, or they're not acceptable for diversion, or they don't want diversion. But typically when we receive referrals from these sources, the people are not receiving wraparound, fully immersed treatment in the jail like they would have been if they were coming from a designated facility. So we see a lot of these people where they reconstitute much quicker on their conservatorship because they just never were on any treatment and were not necessarily resistant to it. So those are kind of the two pools of referrals we get. And a lot of times in today's world, they cross between different types of referrals. One person may have gotten referred from a hospital, may have reconstituted, may be deemed not gravely disabled in court, goes out, lives fine for a little while, and then maybe gets caught up in the criminal justice system. We see a lot of that cross-pollinating these days, unfortunately. We can move on to the next, next slide. Oh, I'm sorry, this is the right slide. I think the slide deck I'm using is a little bit different from this one. So what is grave disability? I think Jim and Gail mentioned very heavily that there will be a different edition on January 1st, 2026 of what grave disability means. As for this current moment till December 31st, grave disability is a condition which, as a result of their mental health disorder, is unable to provide for their basic personal needs of food, clothing, and or shelter, and is unwilling to accept voluntary treatment. I don't know if anyone on the call is dealing with minors. It's slightly different, but mostly the same. The same argument is about the basic needs of food, clothing, and shelter. But really, it's about even when someone provides all of the food, clothing, and shelter, the person's unable to utilize it due to their mental illness. Moving to the next slide. Sorry, these are the involuntary roles. We can actually move on to the next one. And before we talk about the powers of the person, just talking about the new SB 43 language. So we talked about food, clothing, and shelter as being some of the basic needs that someone is unable to provide for themselves due to their mental illness that would deem them gravely disabled. Starting January 1st, 2026, the addition of necessary medical care as a basic need and personal safety as a basic need is added to those three current basic needs already. So how it typically would read is, as a result of said mental health, you are unable to provide for any of those five and or, right? all of those five, any of those five basic needs: food, clothing, shelter, personal safety, and necessary medical care. So personal safety is a bit of a broad term, but necessary medical care is a very specific term where if untreated, great bodily harm, injury, or even death could occur to that person. And there's actually a health and safety code that maybe I could put in the chat later, but that specifically talks about that uh, necessary medical care, because it's not like not getting your flu shot, right? It has to be just as severe as the other three categories of food, clothing, and shelter, where if you're not able to provide for it, that it can lead to loss of limb, loss of life, loss of other major functionality to your body and to your mind. One of the other changes to SB 43 is, I know that Gail and Jim talked about, if you go into the hospital at this moment, you talk about substance use, it's a whole different conversation right now. But starting January 1st, 2026, anyone who has either a co-occurring severe substance use disorder or even a standalone severe substance use disorder will be deemed gravely disabled if, due to that co-occurring mental health and substance use or standalone substance use disorder, that they're unable to provide for their food, clothing, shelter, necessary medical care, and personal safety. So those are some of the different elements that will come online January 1st. And I promise in our December call, I think, Gail, we're meeting again in December, right? Yeah.
We are.
Okay. We'll have updated slides so that everyone can have updates. I believe I'm also presenting at the NAMI Greater LA County at the endowment on October 28th. If I know there's a lot of professionals going to be there, but I know some family will also attend. So we will make sure we have that available. The DMH has actually an SB 43 site up for information. So I will, after I'm done talking, I can put it in the chat so that people can access the SB 43 site, because a lot of professionals are confused about when are we enacting and what is the new language. So I want to make sure all our families are also in tune. And then before we move on, because we're talking about powers of the person in this slide. So these are all the powers of the person, which is, one of them is, again, to put someone in a locked facility, right? Because you have someone who's very acute, you don't want them to just walk out because their delusions are telling them that they need to go outside to the street to get their treatment or whatever it may be, right? And then one of our other powers that you see on the bottom is to require treatment with psychiatric medication. When it comes to SUD treatment, there are no locked SUD treatment settings. There is change in legislation to incorporate into locked setting current LPS type facilities, SUD treatment components, but we don't have that as of today. I'm not sure that anyone in the county will have anything running where it's a locked facility that provides SUD treatment. And also, I'm not a clinician, but there are clinicians on this call. There might be some mixed results about when you put somebody in a locked setting for SUD treatment, how helpful, how much efficacy there is to that treatment because of the issue of someone being in a locked setting. Most SUD treatment in the United States is voluntary. So to that point, there was a question in the chat about, would the conservatorship powers of the person allow you as a conservator to place that person into a residential SUD setting? There shouldn't be a problem with that. Treatment is treatment for SUD treatment, although there is, MAT, medication assisted treatment, and hopefully maybe one of the clinicians can touch on that if needed. But aside from that, a lot of what SUD treatment is the grunt work, right? Therapy, other practices that are not necessarily what we are used to in the LPS world of just involuntary medications and keeping somebody in a secure situation. So in terms of the spectrum of SUD care, an SUD residential center is the highest level of care that we would be able to put someone in, because that is the highest level of care that exists aside from an acute setting like a hospital. And then typically all the other levels of care within the SUD substance use disorder spectrum are, you live in a place and then you go somewhere to get your treatment. And I'll have Linda correct me if there's anything else further in her section of the presentation. Let's move on to the next slide. Gail and Jim talk a lot about what you guys should already be kind of prepping in advance. But I do want to let you know, as the public conservator, we, the public guardian, if we are appointed as a conservator, we get estate on every single case. You as a private conservator typically may not, right? If it is warranted, you can seek it out, but oftentimes you guys just become the representative payee, but it depends on the situation. But we as the conservator, we typically 99.9% of the time, we will seek the conservatorship powers of both the person and the estate, and we will take in all the assets, we will apply for all the benefits needed, and then we will make sure that the person is not over resources, that all the SSI, SSDI, Medicare, Medi-Cal, any other benefits, VA, we apply for that. Any other benefits that they would be due, we apply for that. Also because legally we have to, right? Not only do we have the authority, we are held to a fiduciary standard. So at the end of every conservatorship period, we submit an accounting for the court to review, and any other parties that are noticed in that, they can also review the accountings to make sure that we've spent every penny and collected every penny as appropriate. And then, of course, we can take more drastic action on assets in the conservatorship, but typically we will get court orders or court authority to do things like sell a home or do other things like write off debts and whatnot. Gail, I think you guys mentioned student loan debt. I don't know about student loan debt, but we will try our best to consolidate debts and send out notices that we will not be paying off most debts because most of our conservatees are not in a position to pay them, and we can settle for hopefully pennies on the dollar, or we'll just write them off and then just wait for their credit to improve.
Yeah. On that student loan debt, James, what they'll do is they will waive it for 3 years. Now, if the conservatee gets better and they get a job paying a lot of money, then that debt will it'll come back.
That's what you meant. Okay, like a deferment or forbearance.
But after the 3 years, it's gone. That's it.
Gotcha. Okay. Let's move on to the next slide. And these are some of the restrictions. Again, you guys as private conservators, most likely, some of them are kind of like no-brainers, right? Like Power 9A, we typically try to seek because until someone's fully stabilized, that's not something we really want to even be delving in, right? Especially in today's time. Although the Second Amendment gives people those rights, that's why we ask for specific restrictions so that we keep people safe during their time of intensive psychiatric treatment. One of the things I wanted to also touch on is, I'm sorry, Gail, did you have a question?
I was just going to say on number 9, the state does that, but the federal government for 5 years, once they're on a conservatorship, it's my understanding for 5 years they cannot own or possess firearms at all or shoot them either.
So that might be something each person talks to their attorney about, because as you know, there's HIPAA and then there's LPS conservatorship, which is confidential to a further degree than even just HIPAA, because HIPAA is disclosed based on medical need to medical practitioners, whereas LPS conservatorships are meant to be completely private. And as to your point, because you talked about Britney Spears, obviously probate conservatorships are not confidential. You can look them up, right? Because probate matters are not just conservatorship, but decedent estates, which a lot of people look up to see, do I have an inheritance coming, or like, some action happened on some estate. LPS conservatorships completely confidential, including if you show up to LPS court and they want to have a hearing on something, they potentially they could clear the courtroom to give a person complete anonymity. So there is some of that as well. But I did want to touch on you as the private conservator or us as the public conservator and the treatment teams. When someone's on an LPS conservatorship, um, I think sometimes there's this misconception that once people get the involuntary treatment, that everything's kind of gravy. But I do want to kind of level set because there are many challenges. I'm sure both of you, Gail and Jim, know, but uh, people go into a locked facility and you're mandated to take medications. Let's say they're not an injectable. Nobody is, and God forbid, but nobody is making people swallow pills by holding down their nose or anything like that, right? There's a care component to this and a treatment component to this. It's a lot of reminders, and what typically would happen is someone gets worse, even in a locked facility, they may get worse because they're not compliant to the point that they end up getting sent to an acute facility for treatment, right? And so typically, people have that cycle and they have to think about other treatment components. But you guys, as maybe potential LPS conservators in the future, those are not things that facilities can do to say, can't you just make them take their medications? There is that treatment component where it needs to be humane and within, clinical parameters. So if someone is on oral meds, I think a lot of it's just encouragement, reminders, and maybe a little bit of a carrot, right? If you do this, if you don't do this, maybe you can't go out on the pass. There is some of that barter and trading, but it's a very pragmatic and practical component. Let's move on to the next slide. So this will be a lot of people on tomorrow's call, but again, LPS conservatorships, you need to renew every year. The process is very similar. When we receive an LPS referral, 2 doctors have already signed off on a declaration stating that they have clinical evidence and believe that a person is gravely disabled, and cannot provide for their food, clothing, or shelter due to a mental health illness as of today, right? Typically, in a renewal of conservatorship, you will also need to get doctor's declarations if you are the private conservator. Otherwise, we as a public conservator, we send out our notices to the facilities and their physicians months in advance of this renewal date to get a reevaluation from the clinician saying, do you still consider this person gravely disabled due to a mental health illness? And can we get 2 doctors to declare that, right, on a form that we will submit to the court? And then we submit a report, we give all this evidence. So what you guys do as families, as let's say you don't have a conservatorship yet and you're putting together that mental health history, we as the public conservators, when we're trying to do a renewal conservatorship, we do the same thing. We go over the clinic notes, all our interactions with our client. We're mandated to do at least 4 visits a year, even though most of the staff, I can hear them, a lot of the conservatees, they'll call at least once a week, right? So we put together all this information into a packet and we'll submit that to the court. And then that formal report, it'll have, our input, the treating psychiatrist team's declaration, and then all the clinical notes as needed. And then if the conservatee contests that, then it may or will go to a hearing. That's a trial, like a court trial or a jury trial. And then that particular physician may have to testify at that trial. Of course, sometimes conservatees decide, you know what, I want to stay on conservatorship for another year because for whatever reason, they feel like they need more treatment. And then they can just kind of submit to that conservatorship for the year. This is kind of the same process when you're trying to obtain a conservatorship for the first time, except our timeline is only 30 days to do the investigation and then submit our report, have the hearing, and then either the conservatee or proposed conservatee at that time will submit and say, okay, I agree to the conservatorship, or no, we need to I'm contesting. We need to have a hearing on the matter. I want to take it to trial. Um, at any point in time, if a private party wants to become the LPS conservator, because initially maybe they're a little gun shy, and you guys have at that point maybe had a little bit more experience working with the system. Um, we are able to request that the court appoint a private conservator uh, at any time, but typically at that renewal time period is where we would ask for that. Let's move on to the next slide. Um, so I don't know if uh, typically families who are only looking at LPS appreciate this slide as much, but the public guardian is statutorily required to seek all alternatives to conservatorship. It could be any of these that we put on the screen, which are great programs. And I don't know, Gail, when the last time like any of the FSP administration came in to do a presentation, but that might be I think you might have asked me already, and maybe I forgot that one, but we may want to reach out to them. There's other alternatives to conservatorship where when we talk about the three basic needs, food, clothing, shelter, if there's an element that exists as a program within either the county, the city, the state, federal, if there's a program that can provide that, one, food, two, clothing, those are probably a little bit less of an issue if a person's willing to get food and clothing. And then three, shelter, which is a challenge here in LA County. But if there are programs that are able to provide those three things, those are also considered alternatives to conservatorship, like interim housing or a housing program voucher, uh, a food program, Meals on Wheels. Uh, I know that a lot of people who are on the call may not appreciate hearing that because, you guys have already been through that, but I do want to make sure that I mention that any program that can provide help stymie the need for those basic needs being not met are considered alternatives to conservatorship, and the public guardian will investigate for all of those, including what we call a representative payee program. A lot of people, sometimes they can be very stable, but when exposed to the pains of money management, it really gets to them, and it makes them kind of like decompensate at times. So even a representative payee program where they can make payments to a board and care or some other housing element could be deemed an alternative to conservatorship. And I get that question a lot because, families will kind of jam me up, right? And say, how could you consider a payment program an alternative to a conservatorship? But really, the term grave disability is a legal term. Is not necessarily only meant to alleviate the clinical situation, but those basic needs elements to make someone not gravely disabled. Let's move on to the next slide. So some challenges, just in general, again, probate or LPS, but I'll stick to mostly LPS. You guys can read this slide. There's just not enough involuntary treatment settings where you can consistently get a flow from an acute hospital to a subacute locked facility. That remains a challenge at times. So, I just want to level set that you may get the LPS conservatorship. You as a private conservator may be appointed, and then it will be a challenge working with the system at times to get that bed as timely as you would like, because there's an infinite amount of beds, even though DMH has worked very hard to increase the inventory of beds. There's a huge need for beds based on increased LPS conservatorships. I don't think we put it on the slide, but our LPS conservatorship referral volume has increased in the last 5 years, 125% from fiscal year 2021 till now. We've received more than double the volume of referrals. And so, they haven't quite kept up pace to creating at least secure placements at that rate as well. Some of the other things that'll be challenging as either us, the public conservator, or you as the private conservator, is someone has a RSO status, a registered sex offender status. that's a challenge, especially when someone is no longer or is able to work themselves out of a uh, lock setting, trying to find a place that, is like not close to a school, at a place where they will actually take an RSO is sometimes a challenge. I know a lot of people, they're more amenable to have their loved one come back home actually after significant time spent in a lock treatment setting. But these are some of the issues that you have when you're trying to look at places for people to go. We also have people with pending criminal matters. That's also going to be a challenge. And then you as the private conservator, one of the challenges you will also have is when someone's in a more moderate treatment setting, trying to get a doctor to testify to someone's grave disability is a challenge. We as a public guardian consistently run into this challenge where a lot of skilled nursing facilities or other boarding cares they might have a doctor available to do a declaration of great disability, but if it's ever contested and it's time to have a hearing and a trial on the matter, the doctor cannot really get time together to appear for that, even though they can do a remote appearance. One of the issues with that is the doctors don't get paid for that time. So I think that's part of the issue. And that, most doctors are fairly busy. So that's one of the other issues. And then one of the other issues in getting a referral is that the time period for LPS is very tight. I know a lot of people out there are looking for, that kind of focal point where your loved one may need hospitalization, and then for logistical reasons, sometimes it just doesn't fully work out because maybe we don't get a referral in time to file, or the person clears up before they hit the point where a clinical team may think that a person's suitable for conservatorship. There's a lot of issues there as well. Let's move on to the next slide. Sorry, we went over this one. Let's go on to the next one. I think we're near the end. So this is our main line, and this is our site. You guys have my email and my direct number anyways, but this is our main line. Again, the law is changing January 1st, 2026 for LPS. The term grave disability will have some additional meanings. I'm sure AOT and CARE will remind you of this, but that does not change. SB 43 for the grade disability language doesn't necessarily change anything for AOT and CARE eligibility, but it does for LPS. One of the other things that I want to remind everyone is the 5150 hold and the 5250 hold can be done on a basis of danger to self and danger to others. Those are much more broad categories and much more acute of a category. The subsequent 30-day hold, the 5270, can only be initiated if at that time someone's considered to be gravely disabled. So that's a bit of a difference. You can have a 5150 and a 5250 hold on the three categories of danger to self, danger to others, and or someone is gravely disabled. But you can only continue on to that 30-day intensive treatment hold, the 5270, if you are deemed gravely disabled. And then, then people want to be, then the clinical team may want to hold that person for that further 30-day treatment. Gail, I feel like you asked me to touch on one more point, but I wrote it somewhere else and it escapes my mind, so I apologize.
And I don't recall what it is.
Oh, okay. Maybe we'll take it in the questions at the end.
So since I'm the oldest person here, let me start with some of the things that we've been through for the other two presenters. Just a couple of reminders. So first of all, in the first slide, my phone number is wrong. And I did put my phone number, it's my cell phone I'm using, in the chat. And I will add, or maybe Venus can add for me her and my and probably James' email addresses into the chat. So that's the first thing. The other thing I wanted to mention is that, as you can tell, and you'll learn with CareCourt as well, all three programs presented today have some association with 5150s. So they don't have to have 5150s for AOT. You don't have to have 5150s for care, but those are one of the criteria that can be used, and we'll talk more about care in a minute. So for conservatorship, there has to start with 5150. 2 hospitalizations will qualify somebody for AOT. Generally, those are involuntary hospitalizations. They don't have to be, but generally they are. They start with 5150s. One of the criteria for care is 250s to last within the past 60 days. So each of these programs has a piece that can include involuntary hospitalizations. And one of the things I just wanted to mention about that is that when you're talking to the crisis team or the police, with the police, as Gail and Jim have mentioned, it's very difficult to get them to assist with our crisis teams in getting someone to the hospital. And I've been on a grave disability task force, a California grave disability task force, and the reluctance of police to get involved is statewide. It's not just in LA County. With AOT and care, we have some special relationships that we've developed with some of our law enforcement. So when we need to hospitalize, we try and plan it out, and we will use those folks. But when you're talking to someone about the need to have your loved one put on a 5150, first of all, I'm going to turn off the chat because that's going to. So first of all, to Gail's point, the history that you develop is critically important, the form that she told you. And it gives you lots of examples. And to her point again, please only write down the examples that pertain to your family member. When we see when we see the mental health history and it has every single item listed for your loved one, we know that you've just sort of submitted the form, just like she mentioned that it may be for your daughter and everything is he, because that's what's on the form that you get, the example that you get. So please just put down the things that pertain to your family member. And then we know that it's real and it's valid. If everything is written down there, we tend to not see it as valid. That's number one. And number two, when you're talking to the person, the PMRT, law enforcement, whoever it is, when you're talking about what your family member is saying, give them the exact words. We often, when we go out, they'll say, well, they're just talking crazy or it's all gibberish. We understand that, but we need to know what the gibberish is. We need to know what they're saying. That verbiage is very helpful to us in establishing whether or not they are a danger to themselves, others, or whether they are gravely disabled. So, they may be, you say they're just talking gibberish, and we're saying, well, what are they saying that's gibberish? Well, they're talking about how they'll get all of their nutrients from the sun and they never need to eat again. Well, that's very meaningful for us because that goes toward grave disability and it can go towards some to danger to themselves. Danger to themselves is not just about suicide. That's what we think of first, but it's also putting themselves at risk, wandering in traffic without being aware of their surroundings. Those kinds of things can also constitute danger to self. But it's critically important to give us the words that they are saying because that helps us make that determination and it adds to our ability to be able to hospitalize someone who really, really, really needs to be hospitalized. And then again, when we were just to James's point, when we were just talking, I've written some stuff down, but so in the state of California, there is, when someone is 5150 for danger to self, danger to others, the state has an automatic 5-year restriction from being around, from possessing, from owning, from having access to any kind of weapon. So it not only, we think of it as guns, it's not only guns, it could be swords, it could be nunchucks, it could be any kind of serious crossbows. There is a 5-year restriction if someone's put on a 5150 for danger to self, danger to others. If someone's put on a 5250, there is, for anything, danger to self, others, and there's some question about grave disability, but I just looked it up again. There is a lifetime, so the restriction starts with grave disability on the 5250. For danger to self, danger to others, it starts for the 5150. However, at 5250, it becomes a lifetime restriction, and that's federal. So when someone goes into the hospital reports to the Department of Justice. They fill out a form that says that this person is now a prohibited possessor. So if you have a family member who's been hospitalized and put on a hold, and you have a gun in your home, they are not allowed to have, and they live with you, they're not allowed to have access to that weapon. And if they've been on a 5250, that's lifetime. There is a process for them to be able to get their rights to have firearms or weapons restored. And they see a psychiatrist fills out a form, and they testify again in Hollywood court. And I've seen some of those hearings. It's just the judge, the client, and I believe there is public defender and county counsel there, but or district attorney rather, sorry there. But there is an ability to restore weapons. And we see this sometimes because many of our clients with mental illness end up becoming security guards, and they may have been 5150 in the past, but they in their position, they need to carry a firearm. So they will see a psychiatrist and then go to court to try and get those gun rights restored. Welfare and Institution Code 83010203, those are the things that pertain to law enforcement that give law enforcement the right to confiscate those weapons. So it's just a sense of you to know that there are some laws in the state of California and federally that prohibit folks who've been on 5150s, 5250s from having access to any form of weapon. Another thing that we discussed is right now there are no involuntary drug treatment programs in the state of California. And so, I mean, James can probably answer this more than I can because it's a thing I've been thinking about a lot is with the new criteria with SB 43, when the conservator feels like, and a person is conserved for severe substance abuse only, and they really do need drug treatment, and the conservator says they need drug treatment, and the conservatee says, I'm not sure I want it. From what you were saying, James, they would go into a mental health facility to get that drug treatment, because I don't believe they're going to make any of our our residential drug treatment programs involuntary.
Yeah, that one's a challenge to answer because we don't exactly know what it's going to look like. But from a legal perspective, we will have the ability to consent to involuntary MAT. But where they will get it done is
Right.
a little bit challenging. Most likely at a current LPS facility that will now have a SUD component. If they're really acute and not appropriate for like residential SUD where they would do MAT like everyone else who's there voluntarily.
Got it. Yeah. Yeah. So, because I've been thinking about that a lot because it's a huge paradigm shift for our substance use only providers, because everyone is treated voluntarily. So then now let me get into the care court. So care court was brought about by Governor Newsom, and the way I believe I just heard the other day, the way he envisioned it and some of the original law got changed as it went through the legislature. So it had a few more teeth when he first envisioned it and proposed it to the legislators. It got changed through the legislative process. And so it stands for Community Assistance Recovery and Empowerment Act. It was divided into, the state was divided into two cohorts. And the first cohort, 7 counties began care in October of 2023. LA County chose to be in the second cohort, which started December 2024. However, because we are the largest county in California, there was a lot of pressure from the state, and our Board of Supervisors agreed, and we started a year early, and we started care in December of 2023. Some of the things, you'll notice a lot of what I'm going to talk about in terms of criteria and things very much equate with, they're very similar and the same actually as to what some of the criteria is for assisted outpatient treatment for AOT. One of the differences is that right now care is for folks diagnosed with schizophrenia spectrum disorders only. So that includes schizoaffective disorder, unspecified psychosis, schizotypal personality disorder, and schizophreniform. It is totally voluntary, even though there is a court process. You do not have, whereas some of the other programs, you know, so if someone's been incarcerated, that mental health treatment while they're in jail may qualify them for AOT. That's one of the criteria. They don't need to have been ever put in jail, and they don't need to have been put in jail for care either. Next slide, please. And you can just click them all, Araceli. Thank you. So this is again, the same with AOT, this is by law. So care court is for adults, 18 years of age or older. As I said, they must be diagnosed with a schizophrenia spectrum disorder. There was a law afoot to change that to include bipolar disorder. That got shot down in the legislature during appropriations. They brought up another bill, SB 27, which is again bringing up bipolar disorder with psychotic features. It's believed at this point that that probably will pass. So when that does, it will be instituted immediately. So we will be doing schizophrenia with schizophrenia spectrum as well as bipolar disorder with psychotic features. And we'll talk a little more about that in a minute. So whereas with AOT, they cannot be involved in treatment at all, with care, they changed it and made it a little better. They're not clinically stabilized in current treatment and ongoing treatment. Most of the petitions we've gotten, in reality, the client's not involved in any type of care whatsoever. However, if they're seeing a case manager and they're not seeing anyone else and they're still deteriorating and not doing well, they will qualify for care courts. So they can be in treatment, but they're just not doing well and they're not getting stabilized in treatment. That will qualify for care. Their mental health has to be substantially deteriorating, the same as with AOT. And they're going to need this in order to be safely supervised in the community, because right now they're not safely, they can't function safely in the community without supervision, or they need this to prevent relapse and deterioration. Participation in care has to be the least restrictive alternative, and they have to be able to benefit from participation in the care program. So you see those things are all they're the same as with AOT. Next slide, please. Who can petition? So this is where you come in. Anyone, a roommate over the age of 18 can apply. And when we're talking family now, we're talking any family member or someone who stands in the place of a family member. So, you know, there's an aunt, the parents are not involved. There's an aunt, excuse me, an aunt, a cousin who's very much involved and acts like a parent. That person can file a petition. The other person who can file a petition is the respondent themselves. So that's folks from the family. From the community, police, first responders, police officers, firefighters, paramedics, mobile crisis teams without mobile crisis teams, homeless outreach workers without a person with a mental health clinician on board, paramedics, firefighters, homeless outreach teams without mental health as a piece of the team qualify to refer to care where they don't qualify to refer to AOT. A director of the hospital or their designee, a director of a residential facility, a board and care, something like that, or their designee, and a licensed mental health professional. Those are the folks from the community who can refer to care. And then, you know, the Department of Mental Health can petition. The public guardian can petition where they can't petition for AOT. The public guardian can petition for care, and adult protective services who can't do AOT can also petition for care. Also, the director of a Indian Tribe Health Services program or a judge of a tribal court. And actually, when we have the hearings in care court, the care court judge does ask if especially if the person identifies as Native American, they ask what tribe they belong to, because our judges would have a responsibility to notify the judge of the tribal court of this person's participation in care court. Next slide, please. So this is how the process, and this is what happens. So CARE is one of the programs, one of the very few programs for mental health that begins with a judge's order. Now, I know if someone is in criminal court and they're deemed incompetent, there's an order for them to be sent to the mental health court. But if you're applying for AOT, that starts with mental health doing outreach engagement. If you're going for a conservatorship, that starts with the hospital with mental health folks in the hospital, the doctor, psychologist, determining the person meets criteria and filing an application with the public guardian. This is the one place where you, the family, can file a petition with the court to get treatment for your family member. And so I'll show you in a little bit how to file that petition, but you file a petition with the court, the judge reviews it. If the judge believes it meets care court criteria, they then send it to the Department of Mental Health. And I can say in LA County, I can't speak for other counties, in LA County, the judges are putting everything through, just about everything through. So what's going to be important when you're filling out the care petition that we're going to talk about in a minute is that they have the diagnosis of schizophrenia. They are putting through other diagnoses, I have to say. You want to describe the behaviors, you want to describe the symptoms, you want to describe the way it's having them not able to live safely in the community without supervision. And all of that is outlined in that petition that you're going to fill out. It comes to the Department of Mental Health. It takes about a week for us to get it. They send that packet to our county council, who then sends it to us. We begin outreach and engagement immediately. So we go out, we try and get the person to be involved. A clinician then sees the client, tries to do an assessment, and we fill out a CARE Act report, which says it goes through every aspect of the criteria I mentioned, and it says, yes, we believe that this person does meet the criteria. And if we have difficulty because the client won't speak to us, then then when the next hearing comes up, we get that postponed, or we put in that CARE Act report that it's undetermined because the client won't talk to us. We do look at your petition. It carries a lot of weight with us. We will call you. We will talk to you. We look at the electronic records we have. We look at the electronic records from county hospitals. We do not have access. So if a person has private insurance, has Medicare, those records do not show up in our DMH electronic records unless it's been one of our, unless they've had some contact with the Department of Mental Health. Maybe it was our PMRT crisis team that hospitalized them. Maybe it was one of our law enforcement mental health teams, or maybe at some point they have gotten treatment with DMH in the past. But if they have private insurance, if you have Kaiser, those hospitalizations, all those things are not going to show up in our records. And let me, to that point, the one thing about care is for other DMH programs like the full service partnerships that we've talked about, which is sort of like one-stop shopping, where we're in the field, where people get their case management, their therapy, their medication from that full service partnership, and the care functions in that very same way. Private insurances don't pay for our full service partnerships. They don't pay for outpatient therapy in the Department of Mental Health. Private insurances don't pay for that level of care through the Department of Mental Health. With the CARE Act, it was written into the law that when the judge determines the level of care the client needs, that private insurance must pay for that level of care. And that level of care is going to be provided through the Department of Mental Health. So private insurance must pay for that care. So we go out, we do the assessment, we turn in that CARE Act, and then there is an initial hearing. The petitioner, so you're going to be called the petitioner, your family members called the respondent. The petitioner must appear at that first hearing. You will be dismissed as the petitioner, and the Department of Mental Health becomes the petitioner. You will then be still notified of every single hearing that takes place, and there's lots of hearings that take place in care court. So at that initial hearing, you will appear either virtually or in person. You have a choice. Hopefully your loved one will appear as well. If not, the case usually will get continued. At that point, the judge says you're no longer the petitioner. Now DMH is the petitioner. The other unique thing about CARE is that the judge will then say to the respondent, your family member, do you want, say mom petitions John. The judge will say, John, do you want your mom to be a supporter? So CARE has a piece where someone can be appointed by the court to be that respondent's supporter, which means that that supporter has involvement in every aspect of John's care as much as John allows. So interestingly enough, I thought if people are petitioning their loved ones to care, the person who doesn't want treatment is certainly going to not want mom. John's not going to want mom to be his supporter. But more often than not, John says, yes, I would like my mom to be my supporter, which means that mom's involved in determining his case management needs, mom's involved in every aspect of his treatment. It can be including therapy if John determines that he wants mom involved in his therapy. To Gail's point earlier, we think it's best that clients are able to have a confidential relationship with their therapist to be able to talk about whatever is really important to them, but that's entirely up to John. And so John says, I want mom to bring me to court. I want mom to know about court hearings. I want mom to know about all that, but I don't want mom to help me determine where I want to live, for instance. So you will have as much involvement as John allows. If John says, I don't want my mom as my supporter, the judge will ask if there's anyone else John would like. Now, if John names his drug dealer, the judge is going to vet that and say, no, your drug dealer cannot be your supporter. And more often than not, they do have the person who petitioned them as their supporter. Once that happened, so after that initial hearing, the team, the care team, which consists of senior community health workers who are people with lived experience, substance abuse counselors, medical caseworkers, clinical social workers, MFTs, and the service areas each have a supervising psychologist who is the supervisor of that team. We have 2 supervising psychiatrists, and we have 1 field psychiatrist on board. Another field psychiatrist starts next week, and another one in October. And we also have nurses. So we have a full complement of interdisciplinary staff as a part of each care team. LA County is divided into 8 what they call service planning areas. We call them service areas in mental health. So every service area has teams that consist of the disciplines that I tell you about. So we're going out, we're doing outreach, we're developing a treatment plan with that respondent. The treatment plan will always include medication, therapy, case management, and then whatever else that client needs. If they need to have their SSI established, we will work with them on that. If they need substance abuse treatment, we work with them on that. If they need housing, we get them housing. If the client agrees with that treatment plan, we plan it together. If they agree with that treatment plan, it's called a care agreement. We present that to the judge. The county counsel represents the Department of Mental Health in court. Independent defense counsel attorneys represent the client, the respondent in court. And then, of course, there is the judge. So for a care agreement, everybody signs off. The client signs off, DMH signs off, county counsel, the IDCO attorney all sign off. The judge looks at it. He agrees or she agrees. They may add more to it. They sign it. And at that moment, the person is enrolled in the care court program for 12 months. The person says to us instead, they don't do this care agreement, and they say to us instead, pound sand. Then we have a hearing of the merits to determine, and that's a regular hearing where the Department of Mental Health presents evidence about why this person meets care criteria. Their IDCO attorney the respondent may want to testify about why they don't. The judge makes that decision. Once that decision's made, we develop the treatment plan, which for us is going to be the same treatment plan. The judge signs off on it, and that's when the 12-month begins for the respondent. And then we continue to have hearings all the way through to the 12th month. At the 11th month, we determine if the client's ready to graduate, if they've met their own goals, if they've complied with treatment, if they're housed, if they've been stable, they've not needed to be hospitalized, they've not had encounters with law enforcement, they can graduate. The clients can also choose to stay with care for another 12 months, or if we feel like the client has just not been able to meet their goals and they need more support, then we ask for a reappointment for another 12 months. So the maximum time they can be in care court is 2 years. And even though there is this court order, everything in care is voluntary. The same with AOT. Everything in care is voluntary. And we always put medication in their treatment plan, and we always want them to see the psychiatrist, but there is no ability for us to make someone take medication. All medication is voluntary. So even though it's in the plan and the judge strongly encourages the client to see a psychiatrist and listen to the psychiatrist, excuse me, there is no involuntary medication. The court, both for care and AOT, is extremely, extremely collaborative. The client gets to talk a lot. The judge asks what's working, what's not working, what else can the Department of Mental Health provide for you. The judges spend a lot of time talking to the respondent at court, where that doesn't happen with a lot of other courts, but it does happen with AOT and care. Next slide, please. So these are the forms that need to be filled out, and we can sorry. So this is the way that you petition for care. Sorry, someone sent me a text and I thought it was about this. It was about this. So I wanted to see it. So the easiest way to get to this is if you do lacourt.org/care. And maybe Venus, you could put that into the chat for me as well. So the criteria for care, besides the not stabilized and all of those things, the other two things that you'll see is that either the person's had 2 5250s, the last one within the last 60 days, or they're going to need an affidavit from a mental health clinician who has examined or attempted to examine the client within the last 60 days, attesting to their symptoms and their diagnosis. Having said that, let me say, the judges are putting everything through. So for you, what is important is that Care 100. The Care 100 is fillable online, and there's a new form that they've just put out. If you know that your loved one's been on a 5250 twice, the last time within the last 2 months, go ahead and put that in this Care 100. For some of you, I know your family member hasn't been hospitalized in years, or some of you may have never been hospitalized. Don't worry about that. For some of you, they've never been hospitalized and they haven't seen a therapist in years. Don't worry about that either. Fill out the Care 100, file it, and when we, the Department of Mental Health, go out, we will fill out that Care 101, which is our attestation that we see the client and that they meet the criteria. So by law, these two forms are necessary. In reality, the judge is putting them through with just your Care 100. And then when the Department of Mental Health goes out for that first initial assessment period, we will fill out the Care 101. Next slide, please. The other thing that we have is that in the 11 courthouses in LA County that have family law, they also have self-help centers. This is the phone number, the general phone number for the self-help centers. These are the courthouses that have those self-help centers. You can go into any of those self-help centers. They can help you with the petition. The other thing is the self-help center in the Norwalk Courthouse on the 7th floor is just for filing care petitions. Housed in the Norwalk Courthouse on the 7th floor in that self-help center, we have DMH staff, care court staff that are in that same office to assist. So they're there the whole time that the self-help centers are open. And they're open from 8:30 to noon, 1:30 to 4:30, Monday through Thursday, and 8:30 to noon on Fridays. So there's always a DMH person housed at that Norwalk Self-Help Center. And the other self-help centers all have kiosks with video access to Norwalk. So if you live in Lancaster and you go to the Michael Antonovich Courthouse, you can go to that kiosk and get on virtually with our DMH staff and talk to them about, this is what's happening with my son or daughter or sister or brother, mother or father. And they might say to you, it doesn't sound like they meet care criteria. Here are some other resources that we have. Or let us help you, or they'll connect you to the attorneys at the self-help centers who will help you fill out the form. Even if someone says, we don't think your loved one meets care criteria, if you decide you want to file a petition, you may file the petition. No one can stop you from filing that petition. So does that make sense? So there is mental health staff to be able to assist you in completing that petition and getting that petition filed. Next slide, please. This just shows you where the family law, where the self-help centers are. The court was using WebEx, and last week or 2 weeks ago went to Court Connect. And I don't know about you, James, but I know on Thursday it was down and didn't work at all for care court. So they are having some issues. So respondents, the clients and family members can appear via video or they can appear in person. The judges always like it when folks appear in person, and I think it has more meaning for your family members when they're in the actual courtroom and they see it. They also see how caring and devoted and dedicated these judges are to your family members. But again, for some folks, it's just geographically not possible. When the person is, petitioned, if they want to come to court, it's DMH's responsibility to get them there. If they want to come in person, we will either provide a taxi or transport them. And sometimes families want to bring them and they want to go with families. If they would rather appear via virtually, then we will come out with our laptops and get the person onto the court virtually so that they can participate in their hearings. Next slide, please. So, the next slide, please. So once you fill out that CARE 100, you can fill it out on the computer, and there's a way to e-file it. And there, when you e-file it, there should not be any charge for you at all to e-file this. I know there have been some difficulties in the past. If you're having difficulty e-filing, email me and then, or call me, and then I'll have you email me your petition, and I'll have one of the self-help staff bring it over and help our self-help attorneys. All self-help centers are staffed by attorneys or fellows, legal fellows, I should mention that. And so we'll bring it to our self-help center at Norwalk and get it filed for you. Our court is the same as LPS courts. It's in Division A and B of the Norwalk Courthouse. So Division A is Judge Herron, and he has LPS care and AOT court. Division B is Judge Renee Gilbertson, female, and she has LPS and care. Care court is Tuesday and Thursday mornings at this point. Next slide, please. This just shows you, and so the other thing is sometimes someone may want to go, if you live in Lancaster, they can even go to that courthouse, go into that kiosk and attend their hearings. We haven't had people have not wanted to do that necessarily. Either our staff go out and help the person get on virtually from their home, or they come into court either with family, or we will transport them and assist them. If someone's a little too volatile or a little angry at us, we don't want to have our staff transport for safety reasons, but we will provide a taxi service. We will find a way to get them to court if that's how they want to be in court. Most of the time when folks want to come to court, it's either family or our staff are bringing them into the courthouse. And again, if possible, that is the best way, because it just has a sense of being more real for our respondents. And again, very, very, very collaborative. Next slide, please. We've talked about this. Next slide. The other piece that I didn't talk about, one of the things that another piece of care with the referrals from the public guardian's office. So just as James mentioned that the folks who that before they apply for before public guardian determines they meet the criteria for conservatorship, they have to consider if they meet criteria for care or A or T. Just as they have to evaluate that before they file for conservatorship. When someone is ready to come off conservatorship, both care and AOT are ways to be able to step down. And it is specifically written in the law that care is a way of transitioning from being conserved, where some of your civil liberties and civil rights are taken away, to becoming totally on your own. And so care court is sort of a stopgap where we still have the judges, where there's still court oversight. So things are voluntary, but there is a court oversight. To that end, we meet with the public guardian's office every other week, and they present the cases that are coming up for reappointment hearings that they feel no longer meet grave disability criteria. We go over those cases, and and then when it's appropriate, and most of the time it is appropriate, to be very honest, the person no longer meets criteria, care will go out, do the evaluation, will write the court, will file the petition, and the person becomes a part of care court. So it is sort of a step down from LPS to the next level of care before they are totally independent and on their own with no at all. Again, even though there is the court oversight, it is voluntary. So for our folks, and there's the same with AOT, there is no punishment. If a client doesn't comply with care, there is no punishment at all. There's no remanding to jail. There's none of that. If someone meets criteria while they're LPS criteria while they're a part of care court, we do have the ability, and we do go out and we do 5150 folks. If someone happens to get arrested, which does happen when folks are both on AOT and care, it does happen that a person gets arrested, we will go to criminal court with that person and advocate for mental health treatment. We will let them know they are a part of the care court program or the AOT program if they're with AOT. So we will advocate. If a person is involved in our program and we feel like they need a higher level of care, we do not have any ability to be able to file for apply for an LPS conservatorship. Care court is totally voluntary. We have no ability to apply to the public guardian for a conservatorship. Once we hospitalize a person, we will advocate. And if we're the ones putting the person on 5150, from the time that gurney gets into the ambulance and the doors are closed, we're calling the hospital. We're letting the hospital know that the person is coming to them. We're letting them know all of the issues and the symptoms the person is having and how much they need a conservatorship. AOT does the same thing in both programs. While the person is hospitalized, we'll continue to outreach, to advocate. We visit the clients. We do everything in our power if we feel the person needs a higher level of care, to advocate for that. However, we have no ability to get that person conserved. As James mentioned, it's totally up to, and Gail mentioned as well, it's totally up to the psychiatrist treating that person in the hospital. Next slide, please. Next slide. This just, so you can, I think these are the two ways you can reach the Care 100 petition, but I think the easiest is is lacourt.org/care. Next slide. These are the other ways that you can always get help. So you can call 988. Our access line is 800-854-7771. You now can text. And then if you need general information about housing, about other things, for LA County, it's 211. For LA City, it's 311. And then I think now we can open it up for questions. Thank you very much.
Thank you very